ಕೋರ್ಟ್ ಆಫೀಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಹೇಳಿ ಸರ್.
ಸಾಹೇಬ್ರದ್ದು ಸೌಂಡ್ ಸ್ವಲ್ಪ ಕೇಳ್ಸಂಗ್ ಇಡಿ ಸರ್, ಸ್ಪೀಕರ್.
ಹಾ ಸರಿ ಸರ್, ಆಯ್ತು.
ಅಷ್ಟೇ ಸರ್, ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್.
ಹಾ ಆಯ್ತು.
Two matters, sugar matter, my lord.
Fresh matters.
Fresh matter, sir. Last
Put
time I stay quoted.
With your lordships kindly, my lords.
Fresh matter. Huh? Fresh matter. Put it.
With your lordships kindly, my lord, one mentioning, my lords.
Ah,
This is regarding admission to a deemed university, my lords. Today is the last date of admission, my lords. Vacancy has occurred day before yesterday, my lords, because of NRI student not having taken the seats. Today being the last date, my lord, can I request your lordships to take the matter at 2:30, my lords, because tomorrow onwards admissions cannot be made to the university, my lords. Today being the last date.
Lord, I'm.
Nimda.
Please,
Huh?
please. In my matter, my lord, the senior counsel is making submission.
Your matter.
Please,
He is appearing as a senior counsel.
please, please.
Not as advocate.
So this is regarding Union of India, my lord. The respondent is Union of India and DGHS.
Ah. The matters coming up from the learned single judge.
No, my lord.
No, my
This
lord,
is a
the
fresh
red
matter, my lord,
education
pertaining to
matters
seat
directly
matters
before
of
your
MBBS.
Division bench, directly,
please.
petition.
Please,
Huh?
please, my lord.
Not at 2:30. You
Well,
want
tomorrow is the last date of admission, and the identical matters are covered by the judgment of Supreme Court and other high courts in identical matters, my lords.
We will have it at the end of the list. So
Please,
you be
anytime.
prepared by 12:30, 1 o'clock, you be prepared.
Please, my lord, 12:30, 1 o'clock, I'll be prepared.
Please.
Grateful to my lords.
Seat matrix.
Seat matrix.
Yes.
My lord, serial number 18, my lord.
Huh?
Serial number 18, man, kindly grant 2 weeks, my lord. I have informed other side, my lord.
Informed illappa. They have to be here to say no objection. Yes.
What is seal number 1, Jidaiye Kailasi?
35.
Huh?
Criminal be 35.
Huh?
35, serial number 35.
The other side is here.
Yes, government. Government is informed.
Only government.
What serial number?
35.
Criminal appeal.
Jay Kulkarni is not well.
Santosh Kumar B. Biradar?
35. Mr. Santosh Kumar B. Biradar.
Our Sanjay Kulkarni is indisposed.
Sanjay Kulkarni ilwala matter.
35-2, man.
35. 35.2.
Series 4 appeals are there.
Arun Chodapurkar. Camp. Mr. Santosh Kumar is not here.
Santosh Kumar and Sanjay Kulkarni.
Serial number 35. At the request of learned counsel, Shri Sanjay Kulkarni released this matter on 12th of December. Yes. Yes.
Seal number 1, Jidaiye Kailasi?
I prefer respond number 2, man.
For proxy counsel, madam. Our husharial admitted hospital. Kindly 2 weeks time may be granted.
Report compliance. Urology.
ಹೌದು ರಿಪೋರ್ಟ್ ಕೊಟ್ಟು ಕಳಿಸಿದ್ದಾರೆ ಸರ್ ಬೆಂಗಳೂರು
Huh?
ರಿಪೋರ್ಟ್ ಬಂದಿದೆ
ಎಷ್ಟೇ ಟೈಮ್ ತಗೋತೀರಿ
ಅವರು ಅಡ್ಮಿಟ್ ಇದ್ದಾರೆ ಸುಮಾರು.
ಏನೋ
ಅಡ್ಮಿಟ್ ಇದ್ದಾರೆ. ಐ ಆಮ್ ಫಾರ್ ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್.
ಯಾರು ಅಡ್ಮಿಟ್ ಆಗಿದ್ದಾರೆ?
ವಕೀಲ್
ಕೈಲಾಶ್ ಜಡಿ
ವಕೀಲ್ರಾ?
ಕೈಲಾಸ್
ವಕೀಲ್ ಅಡ್ಮಿಟ್ ಆಗಿದ್ದಾರ? ಏನಕ್ಕೆ?
ಹುಷಾರಿಲ್ಲ ಸ್ವಾಮಿ.
ಹುಷಾರಿಲ್ಲ ಅಂತ ಆಸ್ಪತ್ರೆಗೆ ಅಡ್ಮಿಟ್ ಆಗಿದಾರ?
ಹೌದು ಸೋಲಾಪುರಲ್ಲಿ ಅಡ್ಮಿಟ್ ಆಗಿದೆ.
ಹಾ?
ಹೌದು.
Lord, injury to the bladder, that
Huh?
is neurology bladder is there. His favor is there. His favor is there.
Huh?
His favor is there.
Why is he asking for adjournments like this?
No, he was saying that he's
Counsel
not feeling
admitted
well.
that.
ಲಾಸ್ಟ್ ಟೈಮ್ ಇದ್ರಲ್ರಿ, ಲಾಸ್ಟ್ ಟೈಮ್ ಇದೇ ತರ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂಡ್ರು. We can't understand. at the request of learned counsel for the appellant, released this matter on 12th of December.
Serial number 2. Sudhir Singh or Bijapur.
Where for the respondent, my lord, we complied the direction of the learned single judge, my lord. I filed the affidavit, my lord, that is on 3/9/2024.
Affidavit.
Yes, ma'am.
3/9.
Please, ma'am. It was filed on 3/9/2024. Or we passed the, my lord, detailed order, my lord, at annexure R1.
Yes, what do you say?
Liberty will challenge the order.
Annexure R1,
Please, ma'am.
R1.
order
Pass the detail order.
has been passed by Tahsildar.
Please. Or take notice for R2, my lord. I file memo of appearance.
Learned government advocate takes notice for
R2.
Huh?
R2, my lord.
Respond number 2.
Please.
Learned government advocate submits that complaints affidavit of the second respondent Tahsildar, Bidar district, Bidar Taluk, has been filed along with the copy of order dated 27/5/2024. Full stop. Learned government advocate submits that directions were issued by the learned single judge that the second respondent Tahsildar is required to consider the representation dated 28/11/2022 for mutation of the name of the petitioner in the land records. Full stop. Accordingly, the representation has been considered and a reasoned order has been passed by the Tahsildar. Full stop. Next para. Learned counsel for the complainant submits that liberty may be reserved to the complainant to challenge the order passed by the Tahsildar. Full stop. Next para. Accordingly, the contempt petition stands closed while reserving liberty to the complainant to challenge the order passed by the Tahsildar.
Serial number 3, GG Chagashetty.
Last case, your lordship directed
So you must kindly pass over, my lord. Deputy Commissioner requested the government to issue the notification, my lord. Last occasion, your lordship directed us to whether the Deputy Commissioner is issued the notice, requested the government to issue the notification or not. We requested the government to issue the notification, my lord. And we also requested to the beneficiary to deposit that amount also. That amount is, my lord, they are going to be deposit, my lord, getting the approval from the government. In the meanwhile, also, we requested the government to issue the notification. That is, my lord, letter, I'll produce it, my lord. On that basis, my lord,
You have produced.
I'll produce it, my lord, I'm getting that one.
Huh?
I'm having that copy, my lord, I'm getting the print, my lord.
Pass over.
Please.
Serial number 4, Chaitanya Kumar Chandriki.
Lord, in this matter,
Yes.
there was a direction to cause 40 of my land survey number, my lord. 11 is sketch has been prepared, my lord, but RTC has not been affected, my lord.
Kindly see the prayer of the Lawrence single judgment. Direction of the Lawrence single judge.
To consider representation
Yes.
and carry out the necessary podi and durasti work by issuing notice to all the concerned or having rights over the aforesaid survey number within 6 months.
Yes.
My
But
lord,
we issued the,
11
my
is
lord,
sketch.
annexure R2, my lord. I filed the affidavit, my lord, on 3/12/2024. There, my lord, annexure R2, my lord. Where is it? This is the sketch, my lord. 11 is sketch is issued by the, my lord, survey department. And my lord, accordingly,
What
my
is
lord.
this? Contempt petition was earlier filed.
Yes, my lord, they filed, my lord, that is also I produced for annexure R1. There itself, my lord, there is a,
Affidavit of respond number 2 enclosing compliance order. Affidavit along memo are taken on record since the order has been complied with, the contempt is dropped.
My lord, by oversight, what happened, my lord, they have issued 11 is sketch, my lord. But ROR is not affected, my lord, till date. But 11 is sketch ಮಾಡಿದ್ದಾರೆ, my lord, ಅಷ್ಟೇ ಬಿಟ್ಟಿದ್ದಾರೆ. To the extent of complainant, ROR effect ಆಗಿಲ್ಲ, my lord.
RO
ROR
also
generate
affected, my lord. Kindly see, my lord, this is the RO. Well, joint, my lord, they have to, after the demise of his father, my lord, we have to, my lord, enter jointly, my lord. Joint name is also appeared.
ಎಲ್ಲಿದೆ?
Yes.
Joint ಅಂತ ಇದೆ, my lord. ನಂದು
Now they are seeking, my lord, individual name has to be shown on that. Unless partition deed, my lord, we cannot do it.
11 is sketch ಪ್ರಕಾರ ನಮ್ದು to the extent of complainant ROR generate ಮಾಡ್ಬೇಕಂತ according to 11 is sketch ಕೇಳಿದ್ವಿ, my lord.
How 11 is sketch is prepared?
Based on our representation, they have prepared, my
ಹಂಗ್
lord.
ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. They are right. There has to be a partition. And you have filed one more contempt petition, is
Yes.
it?
Last time, my lord, what happened, by oversight, we thought the ROR is not affected, my lord.
You can file contempt petition however you want,
No, my lord, sorry.
despite the fact that earlier your contempt petition has been dropped.
Sorry.
Huh?
Sorry, my lord, last time, now with oversight in the ROR
What you
generate
should do?
reopen ಮಾಡ್ಬೇಕು.
Can you simply file on one more contempt petition?
No, my lord.
Then
I apologize.
learned government advocate submits that earlier contempt petition was filed by the complainant herein in CC contempt petition, civil contempt petition number 2000057 of 2024. And this court, by order dated 22nd of April 2024, accepted the compliance affidavit filed on behalf of
Taslar.
the Deputy Director of Land Records, Bidar, wherein an order passed by the competent authority was also enclosed. Full stop. That being the position, previous sentence. Full stop. The contempt petition was accordingly dropped. Full stop. However, one more contempt petition has been filed by the complainant, which is not permissible in law. Full stop. Moreover, it is submitted that it appears from the contempt petition that the grievance of the petitioner is that only his name has to be entered in the land records.
No.
To the exclusion of the other family members. Full stop. That would not be permissible unless there is a partition and division of the properties amongst the family members. Full stop. Next para. We accept the submission of the learned government advocate. Stop. We dismiss the contempt petition on the ground that a second contempt petition could not have been filed without seeking leave of this court. Full stop. Moreover, comma, as rightly submitted by the learned government advocate, comma, if the petitioner is seeking entry of his name only in the record of rights, comma, to the exclusion of the other family members,
No, ma'am.
comma, that can be done only if there is a partition amongst the family members and a registered document is placed before the competent authority. Full stop. The contempt petition is accordingly dismissed, while reserving liberty to the petitioner to approach the competent authority with necessary documents
Please.
ordered accordingly.
Responder one, my lord, I will take notice. Responder one.
Learned government advocate takes notice for respondent number 1.
Order. Previous matter, my lord, I will also request, my lord. Previous matter, my lord, I received the letter, my lord. May be permitted to produce. Last para, my lord.
Please file it along with the memo.
Please, my lord.
You can't close the matter.
No. Please, my lord. Lords for defer this matter.
Yes. Learned government advocate has filed a memo enclosing copy of a communication dated 29/11/2024 made by the Deputy Commissioner, comma, Vijaypura to the Principal Secretary, comma, Public Works Department, comma, bringing to the notice of the Principal Secretary, comma, the orders passed by the learned single judge regarding the acquisition of the lands belonging to the petitioner, which has been utilized for expansion of the road. Full stop. Learned government advocate submits that the Deputy Commissioner has requested the Principal Secretary, comma, PWD to give administrative approval and release necessary funds for acquisition, and at the same time take all steps to issue a notification of acquisition. Full stop. However, this may take some more time. Full stop. Next para. Release this matter immediately after winter vacation. Yes.
Please.
Seal number 5.
Ma'am, for the complaint lordship.
This matter may be taken up on 16th, my lord. The order has been recalled and has been permitted to join the duties.
Huh?
I'll file. The order has been recalled. Order dated 23/9/2024 has been recalled and complaint is permitted to join the duty and today has joined, my lord. Along with an affidavit, I'll file the order copy, my lord.
My lord, salary has not been, 2 months salary has not been. Virtue of misleading the fourth respondent, they relieve me after the contempt proceeding, they join me, lordship.
Ah,
So therefore, my lord, they are not paid me 2 months salary also. Direct to fourth respondent pay the salary from his pocket also. Principal has misleading the court also.
Yes. What is that you are filing now?
My lord, the order of withdrawal of the order dated 23/9/24.
Ah.
That I'll file along with a memo or affidavit, my lord, of the,
How long was he out of duty now?
my lord, from 23/9/24 to till today he has joined for 2 months.
23/9,
2 months, my lord.
2 months.
2 months.
What about the salary then?
My lord, salary, they are not, I have not received, today I have received instruction, today he has joined the duty, my lord.
Learned counsel for
Respond number 2 and 4.
response number 2 and 4 submits that the said respondents have recalled the
Order dated 23/9/24.
order dated 23/9/2024
24 and permitted the complainant to join.
and have permitted the complainant to join service. And accordingly, the petitioner has joined service today. Full stop. Next para. However, learned counsel for the complainant submits that the petitioner was kept out of job for 2 months and appropriate directions will have to be issued to the respondents to pay the salary. Full stop. Next para. Learned counsel for response number 2 and 3 seeks for a short accommodation
2 and
to
4.
secure instructions
Please.
and make submissions. Full stop. Release this matter after winter vacation.
Please.
Oblige also.
Seal number 6, members of M Patil.
This matter, my lord, SOL is present before lordship, my lord. We issued the endorsement, my lord, regarding photos. Learner single judge, my lord, directed us to consider the representation, my lord. Para number 3.
The last time you had made
Yes,
this
my lord, that's why,
submission.
my lord, now, my lord, we also requested to release that amount also, my lord,
Ah.
by the beneficiary. Beneficiary also requested. And, my lord, today again, my lord, reminder is given to them, my lord. Photos.
Not report of sir.
Beneficiaries, my lord, again, my lord, requested, since there is a contempt case filed, my lord, forthwith, my lord, requested to release that amount. Requesting them to release that amount, my lord, forthwith. That 43 lakhs.
ಆ ಅಮೌಂಟ್ ನೀವು SLA ಬಗ್ಗೆ ರಿಲೀಸ್ ಮಾಡಿದ್ರು ಕೂಡ how will he pay them unless there is acquisition and
That's why, my lord,
determination of
my lord,
compensation?
after there is a circular, my lord, once, my lord, amount is deposited, my lord,
Ah.
then, my lord, SLV has to, my lord, proceed with the notification. That is the circular issued by the government. Unless, my lord, getting the amount from the beneficiary, my lord, we cannot proceed. That is the circular issued by the government on 99/2024.
Notification issue ಮಾಡಬೇಕಲ್ರಿ without issuance of notification how can it be done?
That's why, my lord, they have to deposit first to us, my lord.
ಆಯ್ತು.
Then only, my lord, notification.
Correct. That we have noticed in our previous
That's
order.
why, my lord, now beneficiaries again requested to the principal government advocate, principal government secretary, my lord, to release that amount forthwith. On 2/12/2024, my lord, they
Release ಆದ್ರೂನು he will not be able to release it to the complainant.
that is not immediately we'll issue, my lord. When the amount is, my lord, deposit to us, my lord,
Issue the notification.
my lord, the deputy commissioner will be, my lord, approval from the, my lord, as per the state government.
Huh?
My lord, 11 my lord, notification, deputy commissioner will prepare it, my lord, getting the approval from the state government. That is, my lord, unless, my lord,
Notification has to be issued by whom?
state only.
Only the state.
State, my
government.
lord, that's why,
Ah.
my lord, state, my lord, deputy commissioner after getting approval from the direct state, my lord, 11/1 notification has to be issued.
Ah.
Now, my lord, that amount, unless amount is received by the, my lord, like SLO, but that, my lord, deputy commissioner will not recommend for issue the notification. That is the reason, my lord, we also requested. Even, my lord, also issued the endorsement also. SLO has issued the endorsement. In the affidavit it's filed, my lord. That is Annexure R2. 20th/11/2024. It is, my lord, there is no question of not issuing notification at all. Only directly award has to be passed, my lord. It is because we have already utilized this land, my lord.
ಅವಾರ್ಡ್ ಪಾಸ್ ಮಾಡಬೇಕು ಕೂಡ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಆಕ್ಟ್ ಇದು ಹೊಸದು (23A) in section 23. Karnataka amendment. ಬಟ್ ಅದಕ್ಕೆ ಪ್ರಿಲಿಮಿನರಿ ನೋಟಿಫಿಕೇಶನ್ ಆಗ್ಲೇಬೇಕು.
That is there.
Without preliminary notification, it is not possible.
That's why, preliminary notification has to be issued only approval by the deposit by the, this is the circular issued by the government, my lord. Serial number 6, my lord.
Team 3.
6, my lord, serial number.
Hearing of objections. Again, this can be done only after issuance of the preliminary notification.
That's so, my lord. Before, my lord, issuing the notice, my lord, notification, we have to comply some circle. We have to get the approval for deposit that amount by the beneficiary. Those all the, we have to satisfy it first, my lord, getting the approval for issue of the notification. Last, my lord, in that, my lord, 6, my lord, subpara 9, my lord. ಕಲಂ ಇದರ ಅನುಮತಿ ಕೋರಿ ಸರ್ಕಾರ ಸಲ್ಲಿಸಲಾದ ಪ್ರಸ್ತಾವನೆಯೊಂದಿಗೆ ಭೂ ಕೋರಿಕಾ ಇಲಾಖೆ ಭೂ ಪರಿಹಾರ ಒಟ್ಟು ಮೊತ್ತದಲ್ಲಿ 50% ಠೇವಣಿಯನ್ನು ದಾಖಲೆ ಸಲ್ಲಿಸುತ್ತದೆ.
Even see, they are talking of 23 enquiry. 23A ಅಲ್ಲಿ ಕರ್ನಾಟಕ ಅಮೆಂಡ್ಮೆಂಟ್ ಬಂದಿರೋದು. But all this can be done only after issuance of the preliminary notification. Then the question of enquiry will come. Section 11 ಅಲ್ಲಿ publication of preliminary notification and powers of officers thereon. ಅದಾದ್ಮೇಲೆ all this process will start. ಅದೇ ಇದೆಲ್ಲ ಇವರು ಏನ್ ಮಾಡ್ತಾರೆ, ವಿತೌಟ್ ಎನಿ ನೋಟಿಫಿಕೇಶನ್ ಎಲ್ಲ ಮಾಡ್ಬಿಡೋದು. ಇದು ಎಕ್ಸೆಪ್ಷನ್ ಎಲ್ಲ, ದಿಸ್ ಹ್ಯಾಸ್ ಬಿಕಮ್ ದಿ ಜನರಲ್ ರೂಲ್ ನೌ. They don't want to notify, they just go ahead, utilize the property.
And we also requested the principal government secretary, my lord, that is exemption from social impact assessment ಕೂಡ ನಮಗೆ
ಅದೆಲ್ಲ ನೀವ್ ಏನಾದ್ರು ಮಾಡ್ಕೊಳ್ಳಿ.
ಅದ ತುರ್ತಾಗಿ ಮಾಡೋದಕ್ಕೆ ನಾವು we are trying, my lord. ಪ್ರಪೋಸಲ್ ಅದು ಇದು ಲೇಟ್ ಆದಕ್ಕಿಂತ ನಮಗೆ ಮಂಜೂರಾತಿ ಕೊಡಿ ಅಂತಾನೆ ನಾವು we are requested.
ಪೊಸಿಷನ್ ತಾವು ಕೇಳಲಿಲ್ಲ ನೀವು ಮಂಜೂರಾತಿ ಕೊಡ್ರಿ ಅಂತ.
ಅವಾಗೆ
ಈಗ ಮಾತ್ರ ಕೇಳಿಲ್ಲ.
ಅವರು ಸುಮ್ಮನೆ ಇರ್ತಾರೆ.
ಹೈಯರ್ ಅಥಾರಿಟಿ ಕೇಳಬಹುದಾಯ್ತಲ್ಲ, ಹಿಂಗ್ ಪೊಸಿಷನ್ ತಾಂತಿದ್ವಿ.
ಅದೇ ಪ್ರಾಬ್ಲಮ್, ಅವರು ಸುಮ್ಮನೆ ಇರ್ತಾರೆ ಸ್ವಾಮಿ ಅವಾಗೆ.
ಅಲ್ಲ, ಅವ್ರು ಸುಮ್ಮನೆ ಇದ್ರು ಇವು ಕೆನಾಟ್. ರೈತರು ಸುಮ್ಮನೆ ಇರ್ಬೇಕ್ರಿ ಅಲ್ಲಿ.
ಬೆಣ್ಣೆ ತೋರದು ಇದು ಬ್ಯಾರೇಜ್ ಅದು ಬ್ಯಾಕ್ ವಾಟರ್ ಹೋಗ್ಬಿಡುತ್ತೆ ಸ್ವಾಮಿ ಅದು ಯಾವಾಗ.
This is not an isolated case, sir. Every day we are coming across this type of complaints. Road expansion, you go ahead, ಎಲ್ಲ ಮಾಡ್ಬಿಡಿ, ಆಮೇಲೆ ನೋಡೋಣ.
ಇಲ್ಲ, that is the reason, my lord, we first consent ಆಗಿ ನಾವು ಪರ್ಚೇಸ್ ಮಾಡಕ್ಕೆ ಫಸ್ಟ್ ಗೆ ಅಪ್ರೋಚ್
ಅದನ್ನ ಮಾಡೋದಕ್ಕೆ ಏನ್ ತೊಂದ್ರೆ ಅಂತ.
ಇದರಲ್ಲೂ ಮಾಡ್ಬೋದು, ಬಟ್ ಬಿಕಾಸ್ my lord they are agreeing or not, we don't know, my lord. Simultaneously, if they contact us for consent, my lord, then definitely we'll solve it. Now, my lord, we are requesting that amount will be deposited by the beneficiary immediately, my lord. Yesterday, my lord, you know, all the department has taken the meeting, my lord, is taking very seriously, and they will release that amount immediately. That is, my lord, I learned that.
ಈಗ ಸರ್ಕಾರನು ಇದಕ್ಕೆ ಈ ತರ ಪ್ರೊಸೀಜರ್ಗೆ ಕುಮ್ಮಕ್ ಕೊಡೋ ತರ ಈ ಸರ್ಕ್ಯುಲರ್ ಇಶ್ಯೂ ಮಾಡಿರೋದು. ಭೂ ಕೋರಿಕಾ ಇಲಾಖೆಯು ಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳುವಂತೆ ಕೋರಿ ಸಲ್ಲಿಸಿರುವ ಮನವಿ ಹಾಗೂ ನಮೂನೆ ಎ ಮತ್ತು ಡಿ ಪ್ರತಿಗಳು
ಅದು
ಅವ್ರ ಕಡೆಯಿಂದ ನಿಮಗೆ ಅಕ್ವಿಷನ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಒಂದು, ಅಂದ್ರೆ ಎಲ್ಲ ಈ ತರದ ಕೇಸ್ಗಳೇ. ಅದಕ್ಕೆ ಈ ತರ ಸರ್ಕ್ಯುಲರ್ ಇಶ್ಯೂ ಮಾಡಿ
ಗೌರ್ಮೆಂಟ್ ಅದು ಇಶ್ಯೂ ಕಂಟೆಂಪ್ಟ್ ಇದರಲ್ಲಿ ಪ್ರಾಂಪ್ಟ್ ಆಗಿ ಅಟೆಂಡ್ ಹಾಜರಾಗ್ರಿ ಅಂತ ಅವ್ರದ್ದು ಒಂದು ಸರ್ಕ್ಯುಲರ್ ಐತಿ. ಕಂಟೆಂಪ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನಲ್ಲಿ ಬೇಗ ಇನಿಷಿಯೇಟ್ ಅಂತ ಆಡ್ರಿ ಅವರೇ ಕೊಟ್ಟರು ಸರ್.
ವಾಟ್ ಆರ್ ದಿ ಟೈಮ್ ಗ್ರಾಂಟೆಡ್ ಬೈ ದಿ ಲರ್ನೆಡ್ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಫಾರ್ ಕಂಪ್ಲೀಷನ್ ಆಫ್ ದಿ ಎಂಟೈರ್ ಪ್ರೋಸೆಸ್?
ಪ್ರೊಸೆಸ್ ಇನಿಷಿಯೇಟ್ ಅಂತ ಮಾಡಕ್ಕೆ, ಸ್ಟಾರ್ಟ್ ಟು ಇನಿಷಿಯೇಟ್ ಅಂತ, ಕಂಪ್ಲೀಷನ್ ಅಂತ ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
8 weeks time was granted, man.
8 weeks to start ಅಂತ.
And now after shall be considered by response number 1 to 3 within
ಪ್ರಕ್ರಿಯೆ
8 weeks.
Thereafter 1 year, after 1 year, we have filed contempt petition, my lord. Then they have, within 2-3 days, they are making all these things, my lord. Before that 1 year, clients, petitioners used to visit to the offices, but they have not done any effort to satisfy the notification, issuance of notification or anything.
So we'll have to make some serious observation.
ಅಲ್ಲ, ವಾಟ್ ಹ್ಯಾಪನ್
Everywhere, this is what the authorities are doing.
That is, my lord, there is a direction, my lord, to consider the representation. We considered it representation, issued the endorsement, but we are proceeding for the acquisition ಅಂತಾನೆ ನಾವು ಕೊಟ್ಟಿದ್ದೀವಿ. We are not rejected their request, my lord. we are.
Where is the question of rejection, sir?
That's why, that's why. Unless that is the but
Unless you
endorsement.
say, no, we have not utilized any portion of their property.
ನಾವು ಮಾಡಿದ್ವಿ. We do,
Okay.
that's why not endorsement is issued, my lord. We are admitting that, my lord, we utilize that one. Now, my lord, only thing is, my lord, 11-1 has to be approved by the state.
This order was passed on 5th of October 2023.
Yes, that is.
Ah.
But because, my lord, we made
More
this.
than a year has lapsed.
We requested the beneficiary to deposit repeatedly, my lord. Then last occasion, my lord, when your lordship is taken very serious, my lord, then, my lord, beneficiary written letter to the, my lord's principal.
Well, ಅದಕ್ಕೇನೆ, we have to take
Their
some serious
mistake, my lord. We are
action.
we are not empowered only to, my lord, issue the 11 notification, getting the, my lord, approval from the state government. Their duty, my lord, who has utilized that land, my lord, they have to deposit that amount. But they not done. Minor irrigation department. Minor irrigation department is also present before lordship also.
Executive engineer.
Oh,
Huh?
yes.
Mr. Naganagowda. Huh? ಯಾವಾಗ್ರಿ ಮಾಡಿದ್ದು ಈ ಕಾರ್ಯ ಎಲ್ಲ ಯಾವಾಗ ಮಾಡಿದ್ದು? ಈ ಬರಾಜ್ ಬ್ರಿಡ್ಜ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಯಾವಾಗ ಮಾಡಿದ್ರಿ?
ಇನ್ನು ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ.
ಹಾ, ಇನ್ನು ನಡೀತಾ ಇದೆ. ಯಾವಾಗ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ರಿ? ಹಾ, ಅಲ್ರಿ, ಈ ಬ್ರಿಡ್ಜ್ ಕಮ್ ಬರಾಜ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿದ್ರಲ್ಲ, ಯಾವಾಗ ಮಾಡಿದ್ರಿ ಅಥವಾ ಯಾವಾಗ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ರಿ? ಹಾ, ಏಪ್ರಿಲ್ ಯಾವ ಏಪ್ರಿಲ್? ಹಾ, ಏನ್ರಿ ಹೇಳ್ತಾ ಇದೀರಾ? ರಿಟ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿರೋದು 2023ರಲ್ಲಿ. ಯಾವಾಗ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ರಿ ಅಂತ ಕೇಳಿದ್ದು ಪ್ರೋಸೆಸ್. ಈ ಬ್ರಿಡ್ಜ್ ಕಮ್ ಬರಾಜ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡೋದನ್ನ ಪ್ರೋಸೆಸ್ ಯಾವಾಗ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ರಿ? ಯಾವಾಗ ಅಂತ
ಟೆಂಡರ್ ಯಾವಾಗ ಹಾಕಿರಿ? ಅದು ಟೆಂಡರ್ ಹಾಕ್ತಿರಲ್ಲ
ನಿಮ್ಮ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಟೆಂಡರ್ ಯಾವಾಗ ಕಾಲ್ ಫಾರ್ ಮಾಡಿದೀರಾ?
ಟೆಂಡರ್ 22 ಮಾರ್ಚ್
22. ಹಾ, ಹೆಂಗ್ ಮಾಡಿದ್ರಿ? ವಿತೌಟ್ ಅಕ್ವಿಸಿಷನ್.
ಸರ್, ಗೌರ್ಮೆಂಟ್
ವಿತೌಟ್ ಅಕ್ವಿಸಿಷನ್ ಹೆಂಗ್ ಮಾಡಿದ್ರಿ?
ಕನ್ಸೆಂಟ್ ತಗೊಂಡ.
ಏನ್ ಕನ್ಸೆಂಟ್ ಅಂದ್ರೆ?
ಬಿಡ್ರಿ, ನಿಮ್ಗೋಸ್ಕರ ಬೆನಿಫಿಟ್ ಮಾಡ್ತಾ ಇತ್ತು.
ಹಾ,
ಗಾಡಿ ಮಾಡಿಸ್ಬೇಕು.
ಸರಿ ರೀ, ಅಕ್ವಿಸಿಷನ್ ಪ್ರೋಸೆಸ್ ಯಾಕೆ ಫಾಲೋ ಮಾಡಲ್ಲ ಅಂತ? ಯಾಕೆ ಅಮೌಂಟ್ ಯಾಕೆ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ?
ಗೌರ್ಮೆಂಟ್ ರಿಲೀಸ್ ಮಾಡ್ತೀವಿ.
ಅವ್ರೇನ್ ಮಾಡ್ತಾರೆ? ನೋಡ್ತಾರೆ ನೋಟಿಫಿಕೇಶನ್ ಕಾಂಟ್ಯಾಕ್ಟ್ ಇವ್ರು ಮಾಡೋ ತಪ್ಪು.
ಅವಾಗ ಅಟ್ಲೀಸ್ಟ್ ಆಗಲ್ಲ
ಅಂದ್ರೆ ಇವರು ಅವ್ರನ್ನ ಕೆಲಸ ಮಾಡೋದ್ ತಪ್ಸಿದ್ರೆ ಅವಾಗ ಅವಾಗ ಇವ್ರು ಬೆನ್ನ ಹೇಳ್ತಾನ.
ಕಾಂಟ್ರಾಕ್ಟ್ ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ. ಅವ್ರು ಅವಾಗ ಕೆಲಸ ನಿಲ್ಸರು. ಅವಾಗ
bridge was completed, my lord, at the time of filing writ petition. At the time of filing writ petition, the construction of the bridge was completed, my lord.
No, why do you permit them to enter your land?
Lord, government
government ಆದ್ರೆ
that's the reason we have filed writ petition for the acquisition initiative.
Only giving a representation. We are asking you, why did you allow them to enter your land without acquisition?
Yes, my lord. At the everywhere the governments are without acquisition initiating, my lord, they are doing all these things, my lord.
ಬರ್ಕೊಳ್ಳಿ. The previous occasion. He had recorded the submissions made by the learned government. Regarding the complaints affidavit filed at the hands of the executive engineer, minor irrigation department, GWD division, Kalaburagi, and the objections raised by the learned counsel for the complainant. Full stop. We declined to accept the complaints report submitted at the instance of the special land acquisition officer, who had only stated that he has requested the beneficiary to deposit a sum of rupees 43,50,000 towards payment of compensation for 3 acres, 25 guntas of land. Full stop. We had noticed that there is substance in the submission made on behalf of the complainants that merely because the SLAO has directed the beneficiary to deposit a certain amount, that would not in any way amount to compliance of the directions issued by the learned single judge. Full stop. The government advocate, learned government advocate, was therefore directed to secure instructions as to whether communication has been made to the state government requesting issuance of notification for acquisition. Full stop. Next para. Today, learned government advocate has filed an affidavit of the respondent SLAO
She has taken the charge on July 2024, my lord, present SLO. Thereafter, my lord, is made
ಅವ್ರದ್ದು ರೋಲ್ ಇಲ್ಲ ಕಣ್ರಿ ಇದರಲ್ಲಿ.
beneficiary.
What is the role of the SLAO? Only after all this process is initiated, the role of the SLAO will come into the picture.
Yes.
Preliminary notification has to be issued.
That's why, that is, my lord, after depositing the beneficiary, there is a problem.
ಎಲ್ಲ ತಪ್ಪಾಗಿರೋದು ಇವ್ರ ಕಡೆಯಿಂದಾನೆ, ಮೈನರ್ ಇರಿಗೇಷನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇಂದ. They'll proceed without notification, do everything.
It amounts to professional misconduct. You have committed an offense under section 85 of this act. Without following.
Land Acquisition Act ಎಲ್ಲ ಇದೆ.
It is an offense. They can prosecute you.
ಯಾರೋ ಏನೋ ಪ್ರೆಷರ್ ತಂದ್ಬಿಡ್ತಾರೆ ಅನ್ಬಿಟ್ಟು ನೀವು ಹಿಂಗೆಲ್ಲ ಮಾಡಿದ್ರೆ ಇದೇ ಆಗೋದು. ಕೆಲಸ ಮಾಡ್ಬೇಕು ಅಂತಿದ್ರೆ ಅದನ್ನ ಕಾನೂನು ರೀತಿಯಲ್ಲಿ ಮಾಡ್ರಿ, ಯಾರ್ರಿ ಬೇಡ ಅಂತಾರೆ ನಿಮ್ಗೆ? ಈ ಪ್ರಾವಿಷನ್ಸ್ ಎಲ್ಲ ಕೋಟ್ ಮಾಡಿ ಏನಾದ್ರು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ರೆ ಅವಾಗ್ಲೇ ಸರೋಗಿ ನೀವೆಲ್ಲ. ನೀವೊಬ್ರೇ ಅಲ್ಲ, ಇಡೀ ನಮ್ಮ ರಾಜ್ಯದಲ್ಲಿ ಯಾರು ಈ ತರ ಮಾಡ್ತಾ ಇದಾರೆ ಎಲ್ಲಾರ್ಗು ಇದೊಂದು ಮಾರ್ಗ ಆಗ್ಬೇಕಿದೆ. ರೋಡ್ ವೈಡಿಂಗ್ ಎಲ್ಲ ಮಾಡುವಾಗ್ಲೂ ಇದಾನೆ. Everywhere it is the same thing that we are seeing. ಏನ್ ಹೇಳಿದ್ರು? Of course. Yes, yes. ಏನಂತ ಹೇಳಿದ್ರು?
Forcible expropriation of private property of illiterate widow from rural area by state without following any lawful procedure or compensation. Claim of widow for compensation after half a
ಅಲ್ಲಿ ಗವರ್ಮೆಂಟ್ took a stand that there is delay.
Yes.
ಸಿಕ್ಕಾಪಟ್ಟೆ ಕಾರವಾಗಿ ಬರ್ದಿದ್ದಾರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅವರು.
Guidelines.
ಗವರ್ಮೆಂಟ್ ಅವರು ಈ ತರ ಸಬ್ಮಿಷನ್ಸ್ ಮಾಡಬಾರ್ದು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಂತ. ನೀವು ತಪ್ಪು ಮಾಡೋದು ಮಾಡ್ಬಿಟ್ಟು ಆಮೇಲೆ ಅವ್ರ ಮೇಲೆ ಡಿಲೇ ಅಂತ ಹೇಳೋದು. Without acquisition notification, you utilize the property, and after 50 years, when that lady comes before the court, stand is taken that there is a delay in latches.
Even state is directed to pay legal costs and expenses.
ಅವಾಗ ಸ್ಟಾಪ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ ಡೆಫಿನೆಟ್ಲಿ ದೇ ವಿಲ್ ನಾಟ್ ಡೂ ಇಟ್.
ಅದೇ ಈಗ ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕು ನಾವು, ಇವಾಗ ಜನಗಳಿಗೆ ಹೇಳ್ಬೇಕು. ಆಯ್ತು ದಂಗೆ ಹೇಳ್ರಿ ನೀವೆಲ್ಲ ಈ ತರ ಬಂದ್ರೆ ಆಫೀಸರ್ಸ್ ಅಂತ.
Government ಹಂಗ್ ಮಾಡ್ಬೇಕು. Government has to protect the rights of the citizens.
That's too much.
Here protection of citizens, ಅವರೇ violate ಮಾಡಿದ್ರು.
This barrage was not constructing beneficiary of the farmers
Whatever
only.
it may be.
ಅದಕ್ಕೆ ಅವರು ಒಪ್ಪಿಕೊಂಡಿದ್ದ ಅಂದ್ರೆ ನಾವು ಅವ್ರ ಮೇಲೆ ಬ್ಲೇಮ್ we are not blaming.
ಮಾಡ್ರಿ, there is a provision for consent.
Follow that.
They are ready to give their consent. Do it in accordance with law.
ಕೆಲವು ಟೈಮ್ದಲ್ಲಿ ಸ್ವಾಮಿ ಮಳೆ ಬಂದಾಗ ನೀರು ಶೇಖರಣೆ ಆಗುತ್ತೆ ತಗೊಂಡು ಇಮಿಡಿಯೇಟ್ಲಿ ಅವರು ಫಾರ್ಮರ್ಸ್ ಎಲ್ಲ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿ ಮೀಟಿಂಗ್ ಮಾಡಿರ್ತಾರೆ. ಆಯ್ತು ನಾವು ಎಲ್ಲಿ ಹೋಗಲ್ಲ, ದಟ್ ಡೆಫಿನೆಟ್ಲಿ ಸುಮ್ಮನೆ
ಅದ್ರ ಜೊತೆಗೇನೆ ಪ್ರೋಸೆಸ್ ಇನಿಷಿಯೇಟ್ ಮಾಡ್ಬೇಕಾಗ್ತಾನೆ.
ಅದು ಮಾಡಿಲ್ಲ, ದಟ್ ಈಸ್ ದ ರಾಂಗ್. ಐ ಡೂ ಅಗ್ರಿ.
ಬರೀ ಕೆಲಸ ಮಾಡ್ಬಿಟ್ರೆ ಆಗೋಯ್ತಾ? ಅಕ್ವಿಸಿಷನ್ ಮಾಡೋದ್ ಬೇಡವಾ?
ಅವಾಗೆ ಇಮಿಡಿಯೇಟ್ಲಿ ಪ್ರಪೋಸಲ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ರೆ ಹಾಗೆ.
You view it in any angle, all this is illegal.
That is also observed in Supreme Court decision. Oral consent ಕೊಟ್ರೆ you should not do. Even oral consent ಕೊಟ್ರು
that is not cannot be accepted.
ನೀವು ಅದನ್ನ ಅಕ್ವೈರ್ ಮಾಡಂಗಿಲ್ಲ. That is the law.
ನಾವು ಅನ್ವರ್ಡ್ಸ್ ಮಾಡ್ಬೇಕು,
ಅವಾರ್ಡ್ ಮಾಡ್ಬೇಕು ನೀವು, ಇಲ್ಲ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಬೇಕು.
ಈಗ ನಂತರ
ಮಾಡ್ಕೊಂಡು ಅದು ಬೇರೆ.
ನಂತರ ಕೇಸ್ಗಳಲ್ಲಿ we are taking very keen interest ಮಾಡೋದು. Unless your notification will not go, that is there. ಅದು ಹಿಂದಕ್ಕೆಲ್ಲ ಮಾಡ್ಕೊಂತ ಹಂಗೆ ಬಂದ್ಬಿಟ್ಟು.
Stating that she has taken charge as SLO on 19/7/2024, and thereafter issued notice to the executive engineer, minor irrigation department to deposit the amount. Full stop. Next para. We are not satisfied with the affidavits being filed at the hands of the SLAO and the executive engineer. Full stop. What is required is prompt action at the hands of the deputy commissioner and the state government through the minor irrigation department to initiate action to notify acquisition of the lands in question and thereafter proceed in accordance with law. Full stop. Next para. We consequently direct the first respondent, principal secretary, the revenue department, as well as the principal secretary, minor irrigation department, to take the matter seriously and ensure that a notification is issued in terms of the Right to Fair Compensation Act, 2013, which would enable the SLAO to determine the compensation thereafter. Full stop. It is no doubt true that provision is available under the Act for entering into an agreement with the landowners. Full stop. But then those process will have to be followed only after issuance of the preliminary notification for acquisition, which would be the starting point for all other process. Full stop. Next para. We therefore direct the principal secretary, minor irrigation department, to ensure that all orders are issued for issuance of a preliminary notification, which would enable the SLAO to proceed to determine the compensation. Full stop. Next para. A copy of this order shall be served on the learned government advocate. Full stop. Next para. Release this matter on 6th of January 2024.
Seven, Harshvardhan or Malik Patil.
This is awaited. Service is awaited for accused 1 and 2.
Notice survey. Notice survey.
Awaiting, sir.
This one.
Lord, the aided institution, Lord,
Yaru?
respondent
Notice has to-
accused 1 and 2.
Ex-deputy director of public instruction.
Yes. DDPI, present DDPI and the earlier DDPI. This is a case where, Lord, there was a direction to, Lord, consider the application for renewal. Lord, that is not done. Lord, from last 12 months, Lord, the aided institution employees are.
Both of them are your officers.
Yes, my lord, I received the instruction, my lord. We
Ah.
requested the institute, my lord, to provide some documents, my lord. Those documents is not given by them. What up, sir? For renewal of the, my lord,
Why are you not entering appearance for response number 1 and 2?
that notice is not yet served, my lord. That is the problem. Yes, I called the, my lord, yesterday, my lord, I get this document. And DDP is also present. I'll take notice, my lord.
Reorganization. Renewal of recognition.
We sought, my lord, certain documents from the institution, my
An
lord.
aided institution where, my lord, the annual renewal was required to be done. My lord, we had applied for, my lord, renewal. That was not done. That application remained unconsidered. My lord, they say that your renewal is not done and, my lord, the aid for the aided, my lord, employees is, my lord, stopped. They are without salary, my lord, for the last 12 months, 12 months.
You should get information as to where this person is presently working. ನೀವು ಎಕ್ಸ್ ಡೆಪ್ಟಿ ಡೈರೆಕ್ಟರ್ ಅಂತ ಹಾಕಿದ್ರೆ ಹೆಂಗ್ ಸರ್ವ್ ಆಗುತ್ತೆ ಅದು? ಸರ್ವ್ ಆಗಲ್ಲ. ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಸರ್ವ್ ಆಗಲ್ಲ.
My lord, my instructions was that, my lord, he is, my lord, under suspension. He is not, my lord, deputed to any. My lord, that was my instruction as on the date of filing. So, my lord, I mentioned, my lord, the present, my lord, DDP at least.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2
ಹೌದು,
ಅವ್ರಿಗೆ ಯಾಕೆ ಸರ್ವ್ ಆಗಿಲ್ಲ ಇನ್ನು?
ಇಲ್ಲ, ಪೊಲೀಸ್ ರಿಪೋರ್ಟ್ ಬಂದಿಲ್ಲ ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ ಕಾಸ್ ಲಿಸ್ಟ್. Police is, my lord, yet awaiting service of police report in respect. ಆಗ್ಬೇಕಾಗಿತ್ತು ಸ್ವಲ್ಪ. Should we have it on Monday, my lord, by that time? My lord, anyhow, my lord, government advocate is there. He can communicate, my lord, through the.
The notice sent to response number 1 and 2 has been dispatched on 28/11.
Yes.
2023. 24. However, the notice is awaited. Full stop. We therefore request the learned government advocate to secure instructions from response number 1 and 2 regarding the complaints of the directions issued by the learned single judge. Full stop. Directions were issued on 5/8/2024 to the Deputy Director of Public Instructions, Vijayapura, to consider the application of the petitioner for renewal of recognition within a period of 30 days from the date of receipt of a copy of the order. Full stop. Next para. Release this matter
Tuesday.
On 12th of December, Thursday.
Great.
Yes.
Whatever documents is there, let them submit it, my lord. They, my instruction is, my lord, they
Any
requested the
compliance is to be
institution
done, my lord,
to,
the
some more, one more notice is issued to them to supply some more documents, my lord. If those documents is supplied, my lord, then it will be considered immediately.
What do you get? Please give.
I'll see that,
Please.
my lord, it's followed.
One copy just more.
Serial number 8, Ganesh Naik.
This, my lord, you not paid the process for issue of notice, my lord.
Needful done, lordship. Needful done, lordship.
Learned
Appearing
counsel
for
for which
petition.
complainant submits that steps have been taken. Full stop. Office to verify and issue notice.
Please, lordship.
Yes.
Hearing on yes, serial number 9, RS Nagali.
This appeal, my lords, I have sought for early hearing. Yesterday's matter, my lords, where, my lords,
Nothing has been found, my lords. Only to that effect, only suspension of
to
sentence.
the
Yes, my
extent
lords.
of only
But,
bail.
In appeal, there is no,
That in every POCSO matter,
Need
in
not.
an appeal will have to
Need
issue. Ata ಏನilla.
ಇಲ್ಲ.
but prosecution has to intimate that.
ನೀವು
That's,
intimate ಮಾಡ್ಬೇಡಿ.
yes, there is no mandatory provision. The coordinate bench has issued that.
Ah.
So to that effect only, it has been continued, my lords.
So we'll fix a date.
Yes.
In the meanwhile, if you want to give intimation, you please give it.
Please.
List this matter for final hearing on. When do you want?
Any first week, any date, second week, anything.
January,
ಅಥವಾ ಇದರಲ್ಲಿ 20th.
January,
ಹಾ, sir.
January, second week. 7th of January.
Yes.
2025.
Please.
Grateful.
Stop. IA number 1 of 2024 is accordingly disposed of.
Great.
Serial number 10, Padluru Satyanarayana Chari.
Filed 2 appeals. One challenging the dismissal of petition for divorce, another challenging the order of restriction of conjugal rights. There is a delay of 132
Respondent has been
days.
served.
Yes, please. Last time he had appeared through VC.
Ah,
Lordship was going to ask him to come down.
yes, yes.
132 days delays.
Hanmantaraya, Mr. Hanmantaraya Sindol.
Manmantraya Sindhu. Responding.
Matter is called out. There is no representation for the respondent. Full stop. Release this matter on 12th of
There is delay of
December.
132 days.
Huh?
132
Our
days.
Banbali, in their presence, we'll do it.
Yes, ma'am.
Serial number 11, Upasagar Patil. Serial number 11. Serial number 11.
Being agreed by the order of the learned single judge, wherein a writ of mandamus on the very same day, a positive direction is given, my lord. Though there is a dispute regarding the title of the petitioner's property. If lordship looks at page number,
Commissioner, City Corporation, Kalaburagi.
yes, my lord, page number 14 of the order
Hmm.
at para 4.
Hmm.
It is also an undisputed fact that the petitioner here were arrayed as a respondent in the said RSA, and their right, title, interest, and position of the subject properties have been upheld by this court, and the same has attained finality and become conclusive and binding upon the respondent corporation. I am not a party to this party to the RSA. my lord.
Ah.
In spite of this, the learned
What
single-
is the direction?
my lord, direction is to enter the mutation khata in the name of the respondent. my lord.
Petitioner.
Yes,
Ah.
though there is only a representation to consider.
What is your contention?
Our contention are filed by way of additional documents, my lord.
Ah.
This property belongs to the government and it is a Gontan land. It was declared way back in the year 1970, prior to 1975. If lordship looks at my memo along with the documents I have produced, at memo type copy 175, regional commissioner has written a letter to the deputy commissioner to see that the land is, they have not proved their title at all, my lord. I am not a party to the RSA, not to the original suit. It was a suit for bare eviction. If lordship permit, I may permit it to read, my lord.
ಹಾ.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಗುಲ್ಬರ್ಗ ನಗರ ಸರ್ದಾರ್ ವಲ್ಲಭಾಯ್ ಪಟೇಲ್ ವೃತ್ತದಿಂದ ಆಳಂದ್ ಚೆಕ್ ಪೋಸ್ಟ್ ವರೆಗೆ ರಸ್ತೆ ಎರಡು ಬದ ಅಗಲೀಕರಣದಲ್ಲಿ ಗುಲ್ಬರ್ಗ ನಗರದ ಜಮೀನು CTS ನಂಬರ್ 1435 ಶರಣಬಸವೇಶ್ವರ ಸಂಸ್ಥಾನ ಜಾತ್ರೆ ಮೈದಾನ ಜಮೀನು ಭೂ ಸ್ವಾಧೀನ ಆಗಿದ ಪರಿಹಾರ ಧನವನ್ನು ಪಾವತಿ ಮಾಡಿರುವುದಿಲ್ಲ ಎಂದು ಆಕ್ಷೇಪಿಸಿ ಡಾಕ್ಟರ್ ಶರಣಬಸಪ್ಪ ಅಪ್ಪ ಪೀಠಾಧಿಪತಿಗಳು ಶರಣಬಸವೇಶ್ವರ ಸಂಸ್ಥಾನ ಗುಲ್ಬರ್ಗ ಇವರು ಈ ಕಾರ್ಯಾಲಯಕ್ಕೆ ದೂರ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿದರು. ಸದರಿ ಜಮೀನನ್ನು ಒಡೆತನ ಕುರಿತು ದಾಖಲಾತಿ ಸಲ್ಲಿಸುವಂತೆ ಸೂಚಿಸಿ ಅರ್ಜಿದಾರರಿಗೆ ನೋಟಿಸ್ ನೀಡಲಾಗಿದ್ದು CTS ದಾಖಲಾತಿ ಹೊರತು ಪಡಿಸಿ ಒಡೆತನ ಯಾವುದೇ ದಾಖಲಾತಿಯನ್ನು ಈ ಕಾರ್ಯಾಲಯಕ್ಕೆ ಇದುವರೆಗೂ ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ಈ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಜಮೀನು ಕುರಿತು ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ವರದಿ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಿದ ತಹಸೀಲ್ದಾರರು ಗುಲ್ಬರ್ಗ ಇವರಿಗೆ ಪತ್ರ ಬರೆಯಲಾಗಿತ್ತು. ಅವರ ಉಲ್ಲೇಖ 1ರ ಪತ್ರದ ಮುಖಾಂತರ ದಾಖಲಾತಿಗಳೊಂದಿಗೆ ವರದಿಯನ್ನು ಸಲ್ಲಿಸಿರುವವರು. ತಹಸೀಲ್ದಾರರು ಗುಲ್ಬರ್ಗ ಅವರು ವರದಿಸುವಂತೆ ಪ್ರಸ್ತಾಪಿತ ಜಮೀನು 1977ರಲ್ಲಿ ಸಾಲಗಿಂತ ಮುಂಚೆಯಿಂದಲೂ ಕಂದಾಯ ಇಲಾಖೆಯ ಇತ್ಯಾದಿಗಳಲ್ಲಿ ಸರ್ಕಾರ ಗೌಂಟಾನ್ ಎಂಬುದಾಗಿ ಇರುವುದು ಎಂದು ಗ್ರಾಮ ನಕಾಶೆ ಪ್ರತಿಯೊಂದಿಗೆ ತಮ್ಮ ಅಭಿಪ್ರಾಯ ನೀಡುವವರು ಹಾಗೂ 1977 ಸಾಲಿನಲ್ಲಿ CTS ದಾಖಲಾತಿಯಲ್ಲಿ ಮಾತ್ರ ಮಾರ್ಪಡಿದು ಮಾಡಿರುವುದು ಕಂಡು ಬಂದಿರುವುದು ಎಂದು ತಿಳಿಸಿದ್ದರು. My lord, there is a dispute regarding the title of that property itself. Government claims that the property belongs to it is a Gontan land. Way back village maps and all show it is a Gontan land, and till date no any ROs are there in respect of that land.
See, there was a process for acquisition.
Yes, my lord. They said, my lord, it is their contention. The respondent contention was there was a process for acquisition and we have to pay the compensation. We wrote a letter to them to furnish all the details. They didn't produce except the CTS records. Later,
What about the acquisition?
there is no any acquisition, my lord. Earlier acquisition which they had challenged before this honorable court have been dismissed till the Supreme Court, my lord. Regarding road widening, they had filed
ಅದ್ರ ಬಗ್ಗೆ ಯಾಕೆ ಹೇಳಿಲ್ಲ?
my lord,
ಅದ್ರ ಬಗ್ಗೆ ಯಾಕೆ ಹೇಳಿಲ್ಲ ಇದರಲ್ಲಿ?
ಅಲ್ಲ ಮುಂದಿದೆ ಅದಕ್ಕಿಂತ ಮೊದಲು ತಹಸೀಲ್ದಾರ್ ಆರ್ಡರ್ ಇದೆ. Prior to that, document number 1 is the Tahsildar order. And on the very same day, the order is passed without permitting us to file any, only a positive direction has been issued regarding that. Within 8 weeks, we have to issue a khata in their name, a positive direction, my lord. though there was a submission that upon verification, it will be done. And to the RSA, I am not a party, my lord, and RSA is only for a suit for eviction, not for any declaration or.
Issue notice to the respondents. The petitioner is also permitted to serve copy of the appeal memo along with annexures on learned counsel.
Shri A.M. Nagaraj.
Shri
A.M. Nagaraj.
A.M. Nagaraj, who appeared for the respondents before the learned single. Full stop. Next para. Learned counsel for the appellant. Kalaburagi City Corporation submits that despite a submission being made at the ends of the corporation before the learned single judge, that
At para 2, page 10.
subject to verification of the records, the corporation will consider the representation given by the respondents herein for entry of their name in the Khata register. Nevertheless, a positive direction has been issued by the learned single judge to mutate the Khata and enter the name of the petitioners in the subject property in all records within a period of 8 weeks from the date of receipt of a copy of the order. Full stop. Learned counsel for the appellant submits that sufficient material has been placed along with the memorandum of appeal to show that earlier too there was a litigation between the respondents herein and the
a private person, my lord, who had occupied that place, the Jatra Maidan. Against them, there was a suit for eviction, my lord.
ಅದು RSL decide ಆಗೋಗಿದೆ.
And regarding widening of road, they had sought for compensation, which has been rejected till Supreme Court. For widening of road, they had sought for compensation, which has been rejected till the Honorable Apex Court, my lord.
You wanted to widen the road.
It was our land, we had widened. They sought
Widened.
yes, that sought for compensation.
ಏನಂತ ಹೇಳಿ? Earlier too, there was such a claim made by the respondents for payment of compensation during the road widening process. Full stop. However, the corporation did not pay any compensation to the respondent and the matter was concluded up to the Honorable Supreme Court. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order in WP number 202805 of 2024 till the next date of hearing.
Please.
Till the next date of hearing.
For trimming of charges.
Lord, in this matter, my lord, here for the respondent. Lord, Lord, you will pass the order, my lord, page number 21, my lord, para number 14. Before that, my lord, para number 11, my lord. And our SLP, my lord, dismissed, my lord, confirmed by your lordship's order, my lord. That is annexure R2. We filed the affidavit of the, my lord, additional commissioner, my lord, on 4/12.
That SLP was heard for admission, it was dismissed.
Yes, on delay
SLP, my lord.
itself it has.
SLP,
delay
lord,
on
preliminary
account of delay.
hearing itself, it is dismissed.
Yes.
Yes.
The SLP that you were talking of on the
Yes, yes,
previous occasion.
yes.
So that was considered and dismissed.
Yes.
ಮತ್ತೆ
On
ಈಗ
2/12. Now, my lord, we implemented the order of your lordship.
Huh?
We fixed the, my lord, all the retirement benefits and the notional promotion. Everything is done. That is-
ಮಾಡಾಯ್ತಾ?
Yes, yes.
Just now they have given the copy, my lord.
All right.
Kindly see, my lord, annexure R7.
Learned government advocate submits that the SLP filed at the ends of the respondents herein has been dismissed by the Honorable Supreme Court. Full stop. Thereafter,
Annexure R5, my lord, order passed by the, my lord, Deputy Director.
The respondent, Deputy Director of
Public
Public
Instruction.
Instructions, Bidar. Has passed an order on 4/12/2024 granting all the retirement benefits
And notional promotion.
and notional promotion to the
Complaint.
complainant hearing. Full stop. Next para. Learned counsel for the complainant submits that he has received a copy of the memo today, and therefore he would like to secure instructions from the complainant. Full stop. Release this matter on 12th of December.
Presence of the officer may be dispensed with, my lord,
Huh?
because presence of the,
For the time being, presence of the respondents is dispensed.
I'll take notice for all the respondents, my lord. I'll
Learned
file, my
government
lord.
advocate for starting early takes notice for all the respondents.
Please.
Yes.
Seal number 13, admission matters, Mahantesh Patil.
Petition, this appeal is not by the husband. Decree of divorce is filed by the
Admission.
Admission.
decree of divorce, my lords, filed by the husband was came to be dismissed.
Dismissed.
House.
Huh.
Now, my lords,
All right. What is there? Admit.
admission, my lords, my request is maybe next week, any date, maybe if the other side is there.
ಬರ್ತಾನೆ ಇಲ್ವಲ್ಲಪ್ಪ ಅವರು ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿಲ್ಲ ಇವತ್ತು ಬಂದಿಲ್ಲ ನಾವೇನ್ ಮಾಡು.
Now he is aged about 62 years. Now they want to, because of the reason that last 2000, from 2010, they are residing separately. And
What do
already
you want now?
he has married also. He want to settle it, my lords, for, because 62 years and he may not be, my lords, in a,
Matter is called out. There is no representation for the respondent. Full stop. Even on the previous occasion, there was no representation for the respondent. Full stop. Next para. Release this matter on 12th of December.
Number 14, SS Asperly.
My lord, this case, I have led an evidence, so marked with the document that as on the date of accident, there is no RC and fitness certificate, my lord. Exhibit R1, I have filed, and I also have led an evidence. For that, they are not producing the.
No RC.
As on the date of accident, there was no RC.
Andre?
It was expired, my lord. Even fitness is also not there. Fitness certificate is also not their vehicle. It is
I am the owner. I have, lots of kindly permit me to file a memo. I produced the RC renewed up to 2024 months. That is I am placing the.
Our copy.
No, my lord. It's not a authenticate, my lord.
It is a
Because
online,
as of the-
online I have taken.
our
this. If
contest
you
is
want-
as on the date of accident, there is no fitness and they would have an updated certificate copy. It is not an.
It is an online application.
No. I have filed certificate copy.
You can get it verified, sir. Instead of making submissions like this, you please ask your officers and go and verify that.
My lord, he is the
If
owner.
it is true that there was a RC and fitness certificate also, then that is the end of the matter.
My lord, I have filed the certificate copy.
ಏನಂತ?
Already I have filed certificate copy, exhibit R1, which is marked as an exhibit. No RC and no fitness, madam.
ಅಂದ್ರೆ
As on the date of accident, 2018 the accident ಆಗಿದೆ. As on the date of accident, the RC was not valid, expired, my lord. Your
Yes,
fitness is also not there, my lord.
ಇನ್ಸೂರೆನ್ಸ್ ಐತನ್ರಿ
My lord,
ವಿತೌಟ್ ಆರ್ಸಿ
my lord,
ಇನ್ಸೂರೆನ್ಸ್ ಪಾಲಿಸಿ ಕೊಟ್ಟದ್ರಲ್ಲಿ ನೀವು
my lord, this insurance.
ಪಾಲಿಸಿ ಹೌ ಕ್ಯಾನ್ ಯು ಇಶ್ಯೂ ದಿ ಪಾಲಿಸಿ ವಿತೌಟ್ ಆರ್ಸಿ
Insurance was valid up to 2017, my lord.
ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿರೋದು.
So,
Yes, ma'am.
known as on the date of the accident, there was no policy.
No, policy is there, ma'am.
How?
Policy is there, ma'am.
ಮತ್ತೆ?
ಆ period ಅಲ್ಲಿ ಇನ್ಶೂರೆನ್ಸ್ ತಗೋಕಲ್ಕೆ my lord,
Please get it verified, sir. Please get it verified.
because he is the owner of the vehicle, he is the best person to produce the.
ಅದಕ್ಕೆ he is producing it.
No, my lord.
So you can go and get it verified from the office of the regional
Transport
authority. That is all you can do. Without getting it verified, how can you simply say, no, we have already
It is
found.
25, they have produced 25, my lord. Subsequently, they might have been renewed, but as
We do not know, sir. Now they have produced some document. Please ask your officers to go and verify whether what they are submitting is correct or not. And you also can get an endorsement. Isn't it? Please do it.
Well, it's kind submission. Ultimately, the pay and request may be disposed.
Huh?
Dispose, I'm for claimant, my lord.
Allala.
He's not deposited any amount.
Allala. Alli, that is, if admittedly there was a policy. ಅಲ್ಲಿ ಅಂತ ಕೇಸ್ಗಳಲ್ಲಿ ಆ ತರ ಡೈರೆಕ್ಷನ್ಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ. ನಾವು if they say no, there was no fitness certificate and the RC was not renewed, then they will have a good ground. Then you will have to recover only from the owner. Learned counsel for
Respondent number 4.
respondent number 4.
Yes.
Owner of the vehicle
Please.
has filed a memo
Please.
along with certain documents. Full stop. Learned counsel submits that the registration certificate of the vehicle shows that the fitness of the vehicle is valid up to 26/10/2024.
15/4/2015.
And tax is also valid up to 12/4/2030. 2030.
Yes. And insurance
And
also.
insurance policy is admittedly valid up to 14/6/2025.
not my insurance, my lord, some other insurance, but no. It does not pertain because my accident is 2018. my lord.
A copy of the same is served on the learned counsel for the appellant. Full stop. Next para. Although learned counsel for the appellant seeks to contend that this information may have been obtained by the fourth respondent subsequently on making the relevant payment. Full stop. Next para. However, we are of the considered opinion that the appellants may get these facts verified from the office of the regional transport officer and thereafter make submissions. I'll list this matter after interpretation.
Seal number 15, Sarada Party, Kulagiri.
Matter is called out. There is no representation for either of the parties. Release this matter after winter vacation.
Seal number 16,
That's I appear for the.
This is the matter, my lord. Last occasion, my lord, your lordship is directed the assistant commissioner to make the survey, my lord. To make the survey and submit the, my lord, report before lordship, my lord. To what extent, my lord, land was utilized and, my lord, by the
Order dated
department.
21/11/2020.
Now
For
we,
the jail.
yes, my lord. We requested the ADLR to make the survey and submit the report, my lord. Your lordship, I have it on 16th, my lord. By that time, we'll file the report, my lord.
At the request of learned government advocate, release this matter on 16th of December.
Please,
On submission, my lords. Annexure G, my lords, report by Tahsildar, my lords, which states the clear description also. my lords.
Alala, separate
We
list,
have
there is a
directed now.
direction by the.
Let us see.
Obliged.
seal number 17, KA Kalaburagi.
Yes.
TCR is received, your lordship.
Huh?
TCR is received, your lordship, on last date of hearing. ಇದರಲ್ಲಿ ನೋಟಿಸ್ ಇಂದ ಸರ್ವಾಗಿಲ್ಲ ಸ್ವಾಮಿ ಪೆಟಿಷನರ್ಗೆ.
ಯಾರಿಗೆ?
ಇಲ್ಲಿದ್ದ ಪೆಟಿಷನರ್ಗೆ ನೋಟಿಸ್ ಸರ್ವಾಗಿಲ್ಲ ಸ್ವಾಮಿ. Hence, ಹೌದು ಸ್ವಾಮಿ. ನಾವು ನೋಟಿಸ್ ಸರ್ವಾಗಿಲ್ಲ ಸ್ವಾಮಿ.
Before the trial court.
ಹೌದು ಸ್ವಾಮಿ. And the ex parte order was passed, which has challenged here, your lordship. Divorce petition, your lordship.
ಇದು ಆರ್ಡರ್ ಶೀಟ್ಸ್ ಕಾಪಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ?
TCR ಬಂದಿದೆ ಸ್ವಾಮಿ.
ಬಂದಿದೆಯಾ?
ಹೌದು ಸ್ವಾಮಿ.
ತೆಗೀರಿ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಡರ್.
6/14 complex.
ಅದೇ ರೆಕಾರ್ಡ್ ತಂದಿದ್ದೀನಿ.
ಹಾಕಿದ್ದಾರೆ.
ಅಲ್ಲ ಅದ್ ಬಿಡಿ ಹಾಕಿರಲ್ಲ, ಖಂಡಿತ ಹಾಕಿರಲ್ಲ. ಅಪ್ಲಿಕೇಶನ್ ಡಿಕ್ಲರೇಷನ್ ಖಂಡಿತ ಹಾಕಿರಲ್ಲ ನೀವು.
Yes, my lord. Order 6 Rule 14A, my lord, have been
Yes.
considered that, my lord. In this matter, my lord, the summons was, has been received, my lord, as an unclaimed, my lord. Here one judgment, my lord. Supreme Court, sir.
You have
Unclaimed.
said, please look into the said provision.
Yes, my lord.
It's a mandatory requirement.
Yes, my lord.
ಅದೇನೆ.
On
We know none of you are following this. Despite amendment being brought to the provision, none of you are filing this kind of a declaration.
my lord, declaration gives in affidavit itself is insufficient
No, no,
because here, my
no,
lord,
no.
my lord, in the case of,
Separate declaration form, sir.
yes, my lord. My lord, even this court.
Anyway, it's an ex parte order.
Yes, my lord.
We will remit the matter back. If we, she will also have an opportunity of hearing. She will lead evidence and then let the matter be decided.
My lord, just my one submission, my lord. This court has passed
Third,
order on, see, order 6 Rule 40A, my lord. On 21st November 2024.
ಅದೇನೆ.
Yes, my lord.
You think it is in your favor?
Yes, my lord. Because here is an,
The appeal
page
ಅನುವಾಗಿದೆ.
number, page number
ಏನ್ರಿ
4,
ಓದ್ತಾ
my lord.
ಇದೀರಾ? What have you understood?
ನೀವೇ ವಿರುದ್ಧವಾಗಿರೋದು ಇದು.
Yes, my lord. But circumstances says that, my lord, where the registered address is party discovered by the court to be incomplete, false, facilitated, the court may either or its own motion on the application in any party. But in this case, my lord, address wasn't correct. I will show that, my
ಅದನ್ನ
lord.
that has to be filed in the form of a declaration. None of you are doing that. That itself is sufficient. That is what we have held here.
No, my lord, if address is corrected, incomplete.
ಅದನ್ನ ಕರೆಕ್ಟ್ I have verified that is the correct address ಅನ್ನೋದನ್ನ you will have to file a declaration form. That is the requirement of law.
My lord, here, para number 7, my lord.
ರೀ ನಾವು ಮೊನ್ನೆ ಪಾಸ್ ಮಾಡಿರೋ ಆರ್ಡರ್ ನಮ್ಗೆ ಹೇಳ್ತಿರಲ್ರಿ ಮತ್ತೆ ನೀವು ಬಂದು.
Correct.
What is this? You don't read the orders properly, is it?
Property.
Ultimately, what have we done in this matter? We have remitted the matter back for reconsideration.
My lord, in the provisions of 14 Rule 8 says.
ಅದನ್ನೇ
Yes,
quote
my lord.
ಮಾಡಿ, none of them are following this procedure. No declaration form is filed. That itself is sufficient to remand the matter back ಅಂತ ಮಾಡಿರೋದು ನಾವು.
It's not applicable on correct address and summons is already served as deemed.
ಆಯ್ತು. ಆಮೇಲೆ allowed. Same terms.
My lord, please taken this
Yes.
consideration on.
The matter will be remanded. You please go there. Yes.
My lord, please, time limitation are filed, my lord.
ಆಯ್ತು.
3 months on,
Yes.
3 months.
Bill number 18, Ramachandra K.
My lord, kindly grant 2 weeks time, my lord.
Huh?
Kindly grant 2 weeks time, my lord. I have informed other side also, my lord.
At the request of learned counsel for the appellant, release this matter.
2 weeks, my lord. 2 weeks, my lord.
2 weeks ಏನಕ್ರಿ? For what 2 weeks?
My lord, I need short accommodation, my lord.
Short accommodation ಅಂದ್ರೆ 1 week, 2 weeks ಆಗಲ್ಲ. 12th of December.
Please,
Lord,
please.
16th, my lord. 16th.
ಆಯ್ತು, 16th of December.
Please.
Serial number 19, Rajesh Doddamani.
Husband's appeal against dismissal of divorce petition. Husband's appeal against dismissal of divorce petition filed under section 13(1)(a) on the ground of royalty. Trial court.
Who filed the petition?
Husband, my lords.
You filed the petition?
Yes, yes.
It is dismissed.
Yes, my lords.
Issue notice to the respondent.
No, notice, she is
ಆಗಿದೆಯಾ?
already served and represented, my lords.
ಹಾ.
It may be admitted.
ಆಯ್ತು, admit. Call
Records.
for trial court records.
Grateful.
Serial number 20, Subhas Mallapur.
Insurance appeal, challenging on quantum and liability.
If you are ready, we will hear.
First time, fresh matter.
First time.
Admission ಬರ್ತಾ ಇದೆಯಾ?
Admission.
I am the caveator, my lord.
Caveat, huh?
Yes.
You are the claimant.
Yes.
Claimant.
Yes.
Only on quantum, huh?
No, quantum as well as.
Liability. Liability.
Violation of permit.
So your notice has to go to,
Contribute to negligence.
notice has to go to
Respond number 5.
Learned Counsel, Shri Nagaraj Patil has entered appearance for
Claimants, respond number one.
response number 1 to 3.
R1 to 4.
4.
To notice to
R5.
respond number 5.
Yes.
Then what about 4?
4, I will undertake, my lord. 1 to 4, I will undertake.
1 to 4 he will appear.
1 to 4, ಹಂಗಾರೆ 1 to 4 ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ. Issue notice to respond number 5. You got a copy of the appeal memo?
Yes, my lord.
All right, yes. ಏನ್ ಬೇಕು ನಿಮ್ಗೆ?
Interim stay, madam.
Huh?
Interim stay, I am ready to
There is no
deposit.
delay.
No.
No delay. Next para. There shall be an ad interim order of stay of the impugned judgment and award in MBC 1549 of 2022 till the next date of hearing, comma, subject to the appellant depositing 50% of the award amount before the tribunal within a period of 6 weeks from today. ಅದು ad interim order ಬೇಡ, interim order, interim order till next date of hearing ಬೇಡ. Interim order of stay subject to zones.
My lord, may I permitted to withdraw the, because they are challenging only one time.
No,
It's a
he's
death
saying
case.
liability also.
No, permit violation, my lord, pay and recovery was, order was there, my lord. Criminal has made the order. Pay and recovery. Death case, my lord, it's 1 crore 21 lakhs, my lord. 50% of deposited amount.
Next para. The claimant shall be permitted to withdraw 50% of the amount that would be deposited by the appellant.
With interest, my lord.
Along with interest. Yes.
B group matter, serial number 21, Ravi B. Patil.
Petitioner was petitioner was an ex-serviceman. After his retirement, my lord, he was appointed to the post of assistant teacher under ex-serviceman reservation quota.
Was appointed as
assistant teacher.
And
under ex-serviceman reservation quota. My lord, in the year 2007, by virtue of Rule 41C, the last drawn pay scale of my lord, the petitioner, as applicable, my lord, during the military in the service, my lord, is applicable as my lord, the salary, basic salary for my lord, the new post. My lord, however, my lord, at the time of issuance of appointment order, my lord, the authorities have, my lord, fixed the basic pay, my lord, which is lesser than, my lord, the amount of basic pay, my lord, which I used to draw. Because, my lord, without making a payment to me, my lord, they had made an entry in my SR book as paid. Therefore, I had approached Lokayukta since I was deprived of a payment, difference payment. Then, my lord, the committee, there was an inquiry, my lord, held, and then, my lord, the inquiry officer held that, my lord, I am entitled for this benefit. Being agreed of, my lord, the officer, my lord, against whom this inquiry, he, my lord, passes a order saying that, my lord, 21 lakhs is recoverable from me, without, my lord, justifying how, my lord, this 21 lakhs is assessed. Therefore, my lord, last date of hearing, my lord, there was a direction to the government, my lord, to produce, my lord, the how, my lord, this assessment is extracted. They have filed along with the memo also. How?
That's fine.
Even if this statement is gone into, that is nowhere applicable to my case, my lord, it can't be.
When did you file?
On 28th November. 28/11/2024, I have been served with the copy. On same day, I have filed. 20th November.
Learned government advocate submits that he has filed a
Memo,
memo on
28/11/2000.
28/11/2020. Stop. Office to put up the said memo. Full stop. Next para. Release this matter on 10th of December, Tuesday.
Interim order in operation.
Interim order granted earlier stands extended till next date of hearing.
Seal number 22, Mahesh Patil.
Yes.
My lord, this matter, my lord, was heard for a while, my lord, on the last occasion. I'm, my lord, candidate, my lord, for selection to the post of police constable, my lord, wherein, my lord, my candidature was rejected for the reason, my lord, that my eyesights, my lord, are not normal. And, my lord, here, my lord, on identical circumstances, my lord, the coordinate bench, my lord, of this honorable court, my lord, had passed an order, my lord, which is at, my lord, it is also with regard to, my lord, the eye vision.
Color blind.
Color blind. Eye vision. That is, my lord, at page.
You are asking for referring the
Yes,
petitioner for
yes,
re-examination.
yes, yes, my lord. In identical matter, my lord, the coordinate bench of this honorable court, my lord, which is annexed, my lord, at page 60, annexure A15.
But now the opinion of the medical board.
Yes, ma'am.
Has been obtained. Medical board of Minto Hospital.
Minto.
That is the expert body in the state.
My lord, it is, my lord, the KC General.
Huh? No, Minto Hospital.
Minto.
Yes, my lord. Yes,
Minto Hospital.
Minto.
That is a hospital specialized for this eyes.
Yes,
now the highest authority has passed the order.
My lord, the page, it is KCR3, page 83, my lord. Page 83. KC General Hospital.
Idu new produce ಮಾಡಿರೋದು.
ಇಲ್ಲ ಅವ್ರ ಮಾಡ್ರಿ ಅವ್ರ ಮಾಡ್ರಿ page 83 ಅವ್ರು ಮಾಡಿರೋದು ನನಗೆ ಡಿಫೆಕ್ಟಿವ್ ಅಂತ ತೋರಿಸಿದಾರೆ ಅಲ್ಲಿ CU.
Where did we find Minto Hospital then?
Page 78, my lord.
78.
Annexure R1.
Annexure R1.
Yes, ma'am.
This is Minto Hospital.
3 OPD doctors
This
are
is
examined.
8/4/2022.
Yes, ma'am.
It is found to be it is found to be defective. Bracket 1/38 plates identified in both eyes on checking color vision with the Edridge lantern test. He was not able to identify any of the primary colors of various intensities in both eyes, suggestive of color vision deficiency in both eyes. Anterior segment examination is normal in both eyes. Idyanidu KC General Hospital.
My lord, it is R3. Here, my lord, ಅದರಲ್ಲಿ ಡಿಫೆಕ್ಟಿವ್ ಅಂತ ತೋರಿಸ್ತಾರೆ.
ಇದು ಡಿಫೆಕ್ಟಿವ್ ಅಂತ ತೋರಿಸ್ತಾರೆ.
ಡಿಫೆಕ್ಟಿವ್ ಕಲರ್
ಎರಡರಲ್ಲೂ ತೋರಿಸ್ತದೆ. ಮತ್ತೆ ಇನ್ಯಾರಕ್ಕೆ ಕಳಿಸ್ಬೇಕು ನಾವ್ ಇವಾಗ?
My lord, any my lord, the third my lord hospital, my lord, in identical circumstances, my lord, this honorable court, my lord, on the very same my lord question of my lord defective eye vision, my lord, had my lord, in fact, my lord, got re-examined the candidate, my lord, and it was later found my lord fit and he was appointed also. Detailed order was passed, my lord. For a moment, lordship may kindly see my lord page 60.
No, but how can we direct him to be examined by a private hospital?
No, I'm not seeking for any, my lord, examination by the private hospital, my lord. Any other, my lord, medical, my lord, board of,
The highest authority.
my lord, my lord, ಈಗ ಅವರು ಇದು ಮಾಡಿ
Hospital in the state is the specialized hospital for eyes.
But there is, my lord, one such, my lord, certificate, my lord, issued by the government hospital, my lord, by themselves, saying, my lord, that, my lord, it's normal.
What is important is color blindness. Other than other defective ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
My lord,
He is not able to identify any of the primary colors.
my lord, here, my lord, now, my lord, the petitioner, my lord, is, my lord, aged barred, and my lord, it's a question of his career. My lord, no harm would be caused, my lord, if, my lord, one medical re-examination is done, my lord, only
ಯಾರ ಹತ್ರ ಮಾಡಿಸ್ಬೇಕು ಅಂತ
any other, my lord, it is, my lord, any other, my lord, the district hospital, my lord, my lord, the court.
That is why we are saying Minto Hospital in Bangalore is the specialized government hospital for eyes. So
Yes.
we can ignore the certificate given by KC General Hospital also. That is possible. But we can't ignore the certificate issued by Minto Hospital, a team of doctors.
My lord, here, my lord, the KC General Hospital, my lord, they have, my lord, returned to, my lord, the Minto, my lord, the page, the real, my lord, examination, my lord, has been done, my lord, by the KC General Hospital, 83.
ಅದನ್ನು ನಿಮ್ ವಿರುದ್ಧನೇ ಇದೆಯಲ್ಲ.
ಇಲ್ಲ, ಅದು ಇದೆ, ಅವರು ಇವರಿಗೆ ಬರ್ದಿದ್ದಾರೆ. That is, my lord, 82, page 82 ಅಲ್ಲಿ. As per the examination report of so-and-so submitted by unit chief V. Dr. Nishant Sultana Kayum and team, Anjaneya has abnormal color vision.
82.
Page 82.
82 is a typed copy of
Type
Annexure
copy.
R2.
Type copy. Type copy.
To the medical superintendent KC General Hospital.
Yes, my lord. ಅವ್ರು ಬರ್ದಿದ್ದಾರೆ. ಅವರು
No, it is written by the director of
Minto
Hospital.
Minto ಅವರು, my lord, ಇವ್ರಿಗೆ communicate ಮಾಡಿದ್ದಾರೆ. My lord, it is, my lord, on the report, my lord, it is, they have not physically examined the petitioner. The physical examination of the petitioner has been done by KC General Hospital. KC General Hospital or physical.
As per the examination report of Mr. Anjaneya, submitted by unit chief, Dr. So-and-so and team, Anjaneya has abnormal color vision deficiency in both eyes. As per this deficiency and the jot specifications mentioned, he may be considered for any desk job which does not require full color vision.
My lord, here KC General Hospital has physically examined the candidate, and my lord, thereafter, my lord, they have sent this, my lord, report to, my lord, the Minto Hospital for their opinion. They have, my lord, in turn communicated to, my lord, the KC General Hospital, my lord, giving this report. My lord, they have not, my lord, physically examined the, my lord, the candidate.
The page number 79, Annexure R1 is from team of doctors, unit Minto Hospital. Eye examination report. Patient named Anjaneya so-and-so has been examined by team of 3 doctors.
As per regional institute of.
Adene ಅವರು they have recommended he can be given some desk work. But ಇದು ಯಾವುದು
Police constable.
Police constable.
Police
ಕಾನ್ಸ್ಟೇಬಲ್ ಆಗದ.
But in
ಆಗಲೇ ನೀವು immediately you should have applied for some other job.
But my lord, in this, my lord, written examination.
Police constable ಅಂತೂ ಕೊಡಕ್ ಬರೋದಿಲ್ಲ, not possible.
My lord, having, my lord, this deficiency, my lord, yes, my lord, it is agreed, my lord, that he cannot discharge the duties of police constable. But, my lord, still, my lord, if it could be, my lord, examined, my lord, for once, my lord, no harm would be caused, my lord.
Now to get it examined by whom anta?
My lord, any.
They are saying the highest medical board of the state, that is Minto Hospital. They have examined and they have given this report.
My lord, but there is.
How can we direct examination by some private doctors now? Agadilla.
Any other, my lord, the medical board, my lord, of the.
That is the highest authority. Insofar as I is concerned, Minto Hospital is the specialized government hospital in the state.
Only, my lord, here, there is no, my lord, appeal, my lord, on the my lord, it would be assumed, my lord, that it would be final.
ಅದು ಎಲ್ಲದಕ್ಕೂ ಆ ತರ ಪ್ರಾವಿಷನ್ಗಳು ಮಾಡ್ಕೊಂಡು ಕೂತ್ಕೊಂಡ್ರೆ ಮುಗೀತು ಕತೆ.
ಬಟ್ ಬೇರೆ ಸ್ಟೇಟ್ ಗಳಲ್ಲೆಲ್ಲ ಅವರು ಮೆಡಿಕಲ್ ಇದರ ಮೇಲೆ ಅಪೀಲೇಟ್ ಬೋರ್ಡ್ ಇದೆ. There could be a possibility, my lord, that even they can, my lord, err, my lord, it is not, my lord, that it's deliberate, my lord. Even, my lord, there is a possibility, my lord, of error, my lord, even at the, my lord, first examination.
Two certificates, one by KC General, one by Minto Hospital.
Yes, my lord, this is
team of doctors.
Both are government hospitals only. Courts cannot sit in judgment over an expert's opinion.
That is there, my lord, but earlier, my lord, there were some identical matters, my lord, which were considered.
See, it depends on facts of each case. It depends on who had examined the patient earlier.
My lord, earlier, my lord, the coordinate bench, my lord, had considered that, my lord, was referred to Minto. They had, my lord.
That is why we are saying, insofar as I is concerned, Minto Hospital is the highest, consists of the medical board, which is the highest in the state.
Insofar as, my lord, the ophthalmologist.
Now, after that one, how can we send it to some other body? Ali, because it was done by some other authority, they have sent it to Minto.
They have sent it to Minto, and, my lord,
that is why that will be the highest body. Then, adadmel matte we can't send it to some other body. Tappagudu.
My lord, I could, my lord, rely only on, my lord, one medical certificate, my lord, which is, my lord, wherein, my lord, it was, it is also a government hospital, my lord, wherein, my lord, it was found, my lord, that at page 27, my lord, it was found, my lord, by the Koppal, my lord, district hospital, which was found, my lord, at color vision.
ಅದೆಲ್ಲ ಆಗಿ ಕೊನೆಗೆ the highest body will be Minto Hospital.
ಇಲ್ಲ, ಇವರು ಆಮೇಲೆ ಇಂಡಿಪೆಂಡೆಂಟ್ ಆಗಿ ಮಾಡಿಸಿದ್ದಾರೆ, ಇವರು ಇಂಡಿಪೆಂಡೆಂಟ್ ಆಗಿ ಮಾಡಿಸಿದ್ದಾರೆ.
ತಪ್ಪು, ಹಂಗೆಲ್ಲ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. When court is directing, it should be the government facility only, highest body. That is why it is called medical board.
In each, my lord, district, my lord,
ಇರ್ಬೋದು. That is why we are saying, insofar as I is concerned, Minto Hospital is the.
They are considered to be the experts.
Yes. Barkul. The petitioner who had applied for the post of civil police constable, bracket ಅಲ್ಲಿ residual and KK region, close. Is agreed on the fact that although he was declared eligible in all other aspects, comma, except the fact that he has been declared of having color blindness in the eyes, comma, had approached the Karnataka State Administrative Tribunal in application number 20117 of 2023. Full stop. However, the tribunal has rejected the application and consequently the petitioner is before this court. Full stop. Next para. Learned counsel for the appellant has strenuously contended and taken this court through several documents filed along with the petition to say that there are other opinions of doctors which say that the petitioner is not suffering from color blindness. Full stop. However, the learned government advocate has pointed out that there are submits that during the course of the recruitment, comma, the petitioner was referred for medical examination on 29/3/2022 to KC General Hospital, comma, Malleshwaram, comma, Bengaluru. Full stop. The team of doctors at KC General Hospital have declared that the petitioner is suffering from color blindness. Full stop. ಇದು ಯಾವಾಗ ಮಾಡ್ಸಿರೋದ್ರಿ ಇದು 8/4/2022 ಮಿಂಟೋ ಹಾಸ್ಪಿಟಲ್ದು
Lord, Minto Hospital on.
Visual activity in the place. Yes, my lord, they have
29/3 ಇದು 29/3/2022 KC General Hospital 29/3/2022 ಏನ್ ಹೇಳಿದೆ? The learned government advocate has also drawn the attention of this court to Annexure R1 filed along with the statement of objections of the respondents that a team of doctors at Minto Hospital, which is the Regional Institute of Ophthalmology, have clearly stated that on checking color vision with the Ishihara chart, it was found to be defective. Bracket ಅಲ್ಲಿ 1/38 plates identified, in both eyes. Full stop. On checking color vision with the Edridge lantern test, petitioner was not able to identify any of the primary colors of various intensities in both eyes. Full stop. It was therefore opined that the petitioner is suffering from color vision deficiency in both eyes. Full stop. ಅದ್ಯಾವ್ದ್ರಿ ಇದು he may be given some desk work ಅಂತ ಯಾವ್ದ್ರಲ್ಲಿ ಇರುತ್ತೆ?
Next page, my
ಅಲ್ಲೇ ಇದೆ.
page 79,
17
R1 part, ಹಿಂದ್ಗಡೆ,
ಇದರಲ್ಲಿ
R2.
page 84.
However, at annexure R2, the director of Minto Hospital, while communicating the report to the medical superintendent of KC General Hospital, Bengaluru, has also opined that as per the deficiency and the job specifications mentioned, the petitioner may be considered for any desk job which does not require full color vision other than field work, which requires color vision. Full stop. In that view of the matter, the learned government advocate submits that there is no infirmity in the impugned order passed by the tribunal. Full stop. Next para. Considering the submissions to the learned counsel for the petitioner as well as the learned government advocate, and on perusing the petition papers, this court is of the considered opinion that when a opinion has been secured at the hands of a team of doctors at Minto Hospital, which is the Regional Institute of Ophthalmology and the highest body in the state, in the government department, insofar as ophthalmology is concerned, cannot accede to the request made by the learned counsel for petitioner to have the petitioner examined by some other body. So, next para. Consequently, we proceed to dismiss the petition.
Serial number 23 for final disposal, MIL Kulkarni.
This is husband's petition for divorce, minutes.
Huh?
Husband's petition for divorce
Huh?
on the ground of cruelty and desertion, minutes. On the last occasion, the parties were present, minutes. And she is a software engineer. He was earlier in Qatar. He was working as an engineer. He has quit the job during COVID and he has settled in Kalaburagi, minutes. So there was an arrangement and it was direction among themselves saying that he would accompany her in Bombay. She is residing at Bombay, minutes. She is well placed. They have a daughter also. Therefore, it was an arrangement saying that he should accompany her at Bombay. He agreed for it, that he would go. But later, there was no date was not mentioned when he tried to call her. Phone was not, that was switched off or not received. After that, minutes, nothing happened. Neither they came forward nor.
The appellant is
Husband.
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 He agreed to go
Yes.
to ಏನಾಯ್ತು?
They got married on 11.
We given the proposal. Husband ಬಂದು ಅಲ್ಲೇ ಮುಂಬೈಲಿ ಇರ್ಬೇಕು. Wife is working in Mumbai in private.
Correct.
ಏನೋ ಕೆಲಸ ಮಾಡ್ತಿದ್ದಾಳೆ. ಇವನಿಗೆ ಏನೋ ಕೆಲಸ ಇಲ್ಲ ಅಂತ
Correct.
ಹೇಳ್ತಿದ್ದಾನೆ.
He has agreed to
ಅಲ್ಲ
come
ಬಂದಿಲ್ಲ
and-
ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಿದ್ರು ಒಪ್ಪಿಲ್ಲ ಅವಾಗ.
ಇಲ್ಲ ಬಂದ್ ಹೇಳ್ತಾನೆ ಆಮೇಲೆ
ಲಾಸ್ಟ್ ಬೆಂಚ್ಗೆ ಬಂದಿದ್ರು ಅವರು. He was came from Mumbai.
Yes.
ಹೇಳಿದ್ಲು ಅವಳು ನಾ
ಬಂದ್ ಇರ್ಬೇಕು ನಂದೇನ್ ತೊಂದ್ರೆ ಇಲ್ಲ ಅಂತ.
He also agreed, but after that they did not turn up and they did not.
Then can we have both the parties before
Present.
the court?
Please.
ಯಾವಾಗ?
ನೆಕ್ಸ್ಟ್ ಮಂತ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್.
After vacation.
ಈಗೆಲ್ಲ ಮುಂಬೈಲಿಂದ ರಜೆ ಮಾಡ್ತಾರೆ.
ಯಾರೋ ಒಂದ್ ದಿವಸ ಮಾಡ್ಕೊಂಡು
ಅಲ್ಲ ಪ್ರೈವೇಟ್
ಬರ್ಬೇಕು.
Monday, Tuesday. Film letter come to.
ಅಂದ್ರೆ ಕಷ್ಟ ಆಗತ್ತೆ.
Second one is cruelty by the respondent. What is the pleadings to that effect in their legal notice issued to me prior to filing this petition? That is the basic foundation for them make allegation against me what I have done. How many years, how many months I am deserted him from their company. Kindly exhibit P4 is the legal notice issued by them, my lords, dated 1/8/2011, in which they have not made any serious allegation. The only single line allegation against me is that I am pressurizing him to give divorce. That made him, that is a cruelty for him. That is the only allegation in their legal notice, my lords. Second, as far as the allegation of cruelty is concerned, apart from that, what desertion is concerned, their contention is that in the year 2009 itself, I have left their company. That is in their pleadings.
Yes.
Further, in their legal notice as well as their affidavit, they have suppressed more information about after I have gave birth to a child. They have celebrated birthday in their house. I remained there for a period of more than their contention only 1 month, as my contention is 5 months. 25/6/2010 is the date of my return to their house. 1/7/2010 is the date of cradle ceremony. After that 1 month, they admits that I have stayed there in their house only. After that, some differences arose. They themselves have advised me to go to my parental house since some misunderstanding is going on between. Meantime, I am also pursuing my MDS course. I have completed my BDS course in Gulbarga, MDS course. That is, when I am pursuing, meantime, my parents have contacted their parents also. I have contacted him also. He is not, he is in a, some difference of opinion is going on. Their parents advise, since she is pursuing her MDS course, let it be completed for some time. In the meantime, I am pursuing my examination. I gave birth to my child also. After return, I gave a birth to I am pregnant at the time of return to my parents' house. Since he is a pregnant and also pursuing MDS course, in between, they have issued a legal notice. Legal notice issued. In there also, they have, within a period of mandatory period of 2 years, they have issued a legal notice. 1 year, my lords. Within a period of 1 year, July 1/7/2010 is the cradle ceremony. They have issued a legal notice on 1/8/2011. After that, I remained with him 5 months. They even assuming for the sake of argument, 1 month also. That is within 1 year, they have issued legal notice to me, asking not me to come and join their company. It is not the case of restitution of conjugal rights notice. It is a notice, give divorce to me. In their notice also, since I am pressurizing him to give divorce, that made him to a cruelty. That my request was that made him that is cruel nature, that is a cruelty. Therefore, he issued a notice to give me a divorce. For that also, on 1/8, immediately, I have on 30/8/2011 itself, I have replied. How their conduct, my lords? 5 addresses. I am ready to come and join. That is there, but I have not given any made allegation. Nothing is there. Routine some family differences allegation. That doesn't mean that that is not in a position to live together. I am ready to, in the evidence also, my lords, I have given reply notice on 30/8/2011 itself. They have filed divorce petition 1/10/2011 before the Bangalore Family Court.
Change of address.
5 addresses they have given notice. Yes. One is, I am pursuing my degree, BDS degree in Bangalore, college notice kalastare. My native place was the Tadkal village in Alam Taluka. That is, I am not residing in there. I am having a landed property there at Pillars. ನನ್ನ ನೇಟಿವ್ ಪ್ಲೇಸಿಗೆ ಅಡ್ರೆಸ್ಸಿಗೆ ಕಳಿಸ್ತಾರೆ. ಇಲ್ಲಿ ನಾನು ಮದುವೆಕ್ಕಿಂತ ಮೊದಲು ಒಂದು ರೆಂಟೆಡ್ ಮನೆಯಲ್ಲಿ ಇರ್ತೀನಿ, ಆ ಅಡ್ರೆಸ್ಸಿಗೆ ಕಳಿಸ್ತಾರೆ. ಎಲ್ಲ ಗೊತ್ತಿರುತ್ತೆ. 5 ಅಡ್ರೆಸ್ಸಿಗೆ ಕಳಿಸ್ತಾರೆ, 2 ಅಡ್ರೆಸ್ಸಿಗೆ ಸರ್ವ್ ಆಗುತ್ತೆ, 3 ಅಡ್ರೆಸ್ ರಿಟರ್ನ್ ಬರುತ್ತೆ. Only to humiliate me in society. My lords, not only that, how they have promised prior to marriage, they are not the they are having what they have assured to my client before marriage. They are having a house in Banashankari. They are having 8 acres of land in Devanhalli. They are having many plots, Hosur 2 acres land. These are the properties informed by them prior to marriage. After marriage also, they have informed about the same. Being such thing.
And it is not there.
Everything is there. But subsequently, what they are, how they are hiding all those, they are some, what the information, they are changing the properties in others' name to avoid the family, the son is there, my lords. He is entitled for the property. How they are trying since from 2011, since from they are changed earlier at the time of marriage and after marriage was also in the name of the son of the, this is appellant, 2 acres Hosur land. Later on, what they came to know that is changed to the other family members. The 8 acre lands in Devanhalli. Now, how many crores they have asking 20 lakhs. The father has sold 10 acres of land to perform the marriage of the respondent with the appellant. That is in Bangalore, my lords. Bangalore entire expenses was borne by more than 30 acres, 30 lakhs of rupees was spent by the father of the appellant to perform her marriage. By selling his, he was having a one house in Gulbarga that was sold. 25 lakhs rupees he has sold. Now the value of that 4 crores. He has sold 10 acres of land. 2 lakhs acre ಮಾರಿದಾರೆ. ಈಗ ಅದು 15 ಲಕ್ಷ ರೂಪಾಯಿಗೆ 1 ಎಕರೆ ಇದೆ. ಮಗಳ ಮದುವೆ ಚೆನ್ನಾಗಿ ಮಾಡ್ಬೇಕಂತ ಇಷ್ಟು ಮಾಡಿದಾಗ ಎವ್ರಿಥಿಂಗ್ ದೇ ನ್ಯೂ. He is not the ordinary person. One of his brother's son was married to a daughter of one R.L. Jalapa's daughter. How the influential persons are there, matters. ಯಾವ ರೀತಿ ಅವರು ಕಂಡಕ್ಟ್ ತೋರಿಸ್ತಾ ಇದೆ. 20 ಲಕ್ಷ 30-35 ಲಕ್ಷ 2006ರಲ್ಲಿ ಮಗಳಿಗೆ ಖರ್ಚು ಮಾಡಿ ಮದುವೆ ಮಾಡ್ತಾರೆ. ತಾನು ಇದ್ದ ಆಸ್ತಿ ಮಾರ್ಕೊಂಡು ಆನಂತರ this was make allegation against me, single allegation. I have done this is a mistake. This is the done. I have that harm their family reputation. My character, so and so, such was my character. Then I do agree for whatever the reason decision will become. But without there being any single, only her parents ಒಂದು ಸಣ್ಣ ಜಗಳ ಇದಕ್ಕೆ ಎಂಟೈರ್ ದಟ್ ಇಸ್ ನಾಟ್ ಆನ್ ರೆಕಾರ್ಡ್. After birth to a child, returned back to their native place. They have cradle ceremony was. ಆ ಕೂಸಿಗೆ ಜ್ವರ ಬಂದಿತ್ತು, ಸರ್ದಿ ಆಗಿತ್ತು, ತಲೆ ಮ್ಯಾಗ ನೀರು ಹಾಕ್ಬೇಡ ಅಂತ ಒಂದೇ ಕಾರಣ ಈಕೆ ಅತ್ತೆಗೆ ಹೇಳೋದು ಕಾರಣ. ದಿಸ್ ಈಸ್ ದ ಬೇಸಿಕ್ ಸ್ಟಾರ್ಟಿಂಗ್ ಪಾಯಿಂಟ್ ಆಫ್ ಎಂಟೈರ್. ಆ ಕೂಸಿಗೆ ತಲೆ ಮ್ಯಾಗ ನೀರು ಬೇಡ, ಜ್ವರ ಬಂದಿದೆ, ಸ್ವಲ್ಪ ಸರ್ದಿ ಆಗಿದೆ ಅಂತೇಳಿ ಸೊಸಿ ಹೇಳಿದ್ರು. ದಟ್ ಮೇಡ್ ದಿ ಅಪ್ಪಲೆಂಟ್, ನನ್ನ ತಾಯಿ ವಿರುದ್ಧ ಈ ರೀತಿ ನೀ ಹೇಗೆ ಹೇಳಿದೆ ಅಂತ. ದಿಸ್ ಇಸ್ ದ ಓನ್ಲಿ, ಅದ್ರ ಮೊದಲು ಯಾವುದೂ ಇರಲಿಲ್ಲ. ನಾಟ್ ಓನ್ಲಿ ದಟ್ ಮೆಲಟ್ಸ್. ಹೌ ನಾನು ಈಗ ಇವ್ರು ಡೈವರ್ಸ್ ಪ್ರಪೋಸಲ್ ನೋಡಿದಾಗ 50 ಲಕ್ಷ ಅವ್ರು ಕೊಟ್ಟದ ಆಫರು, ನಾನು ಯಾವಾಗ 2014ರಲ್ಲಿ 2 ಕೋಟಿ ಕೇಳಿದ್ರು ಕಣ್ಣು ಮುಚ್ಚಿ ಕೊಡ್ತಿದ್ರು ಅವರು. 2 ಕೋಟಿ ಅವಾಗ ಕೇಳಿದ್ರು. ನನ್ಗೆ ಅವ್ರು ಏನ್ ಹೇಳಿದ್ರು, ನಾವು ಕೇಳಿದಾಗ ದುಡ್ಡು ಬೇಡವೇ ಬೇಡ ಸರ್, ನಮ್ಗೆ ಏನಿದೆ ಡಿಫ್ರೆನ್ಸು, ತಾಯಿ ಮಾತು ಕೇಳಿ ಮಗ ಮಾಡ್ತಾ ಇದ್ದ. ಮಗನಿಗೆ ಅಲಿಗೇಷನ್ ನಮ್ದು ಯಾವುದೂ ಇಲ್ಲ. ನೋ ಸಿಂಗಲ್ ಅಲಿಗೇಷನ್ ಅಗೇನ್ಸ್ಟ್ ಹಸ್ಬೆಂಡ್. ಹಿ ಈಸ್ ಆಲ್ಸೋ ನಾಟ್ ಹ್ಯಾವಿಂಗ್ ಎನಿ ಅಲಿಗೇಷನ್. ಕೈಂಡ್ಲಿ ಹಿಸ್ ಎವಿಡೆನ್ಸ್ ಮೆಲಟ್ಸ್. ಹಿಸ್ ಎವಿಡೆನ್ಸ್ ಕೈಂಡ್ಲಿ, ವಾಟ್ ಈಸ್ ದಿ ಪ್ಲೀಡಿಂಗ್ಸ್, ವಾಟ್ ದೇ ಹ್ಯಾವ್ ಮೇಡ್ ಇನ್ ದೇರ್ ಪೆಟಿಷನ್ ಮೇಕಿಂಗ್ ಅಗೇನ್ಸ್ಟ್ ಮೀ. ಏನು ಡಿಫ್ರೆನ್ಸ್ ನಿಮ್ಮ ಮಧ್ಯೆ ಅವ್ರ ಮಧ್ಯೆ ಅಂತ ಕೇಳ್ತಾರೆ. ಕೈಂಡ್ಲಿ ಮೆಲಟ್ಸ್ ಕನ್ಸಿಡರ್. ಅಲ್ಲ, ಒಂದು ಸೆಂಟೆನ್ಸ್ ಇದೆ. ವಾಟ್ ಈಸ್ ದಿ, ಒಂದು ಕ್ವಶನ್ ಕೇಳ್ತಾರೆ ಇನ್ನು ಅವನ ಎವಿಡೆನ್ಸ್. ವಾಟ್ ಈಸ್ ದ ಡಿಫರೆನ್ಸ್ ಬಿಟ್ವೀನ್ ಯು ಅಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ ಹೇಳಿ ಒಂದು ಕ್ವಶನ್ ಇದೆ ಆ ಎವಿಡೆನ್ಸ್. ಡಿಪೋಸಿಷನ್ ಆಫ್ ದಿ appellant evidence matters.
ಫಸ್ಟ್ ಪೇಜ್
ಇಲ್ಲ, ಡಿಪೋಸಿಷನ್ ಅಲ್ಲಿ ಕ್ರಾಸ್ ನಲ್ಲಿ ಲಾಸ್ಟ್ ಲೈನ್ ಲಾಸ್ಟ್ ಕ್ವಶನ್ ಇದೆ. 13th ಪೇಜ್ matters. ಡಿಪೋಸಿಷನ್ ಅಲ್ಲಿ ವಾಟ್ ಈಸ್ ದ ಡಿಫರೆನ್ಸ್ ಬಿಟ್ವೀನ್ ಯು ಅಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಒಂದು ಕ್ವಶನ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ. ಡಿಪೋಸಿಷನ್ ಆಫ್ ದಿ ಅಪ್ಪಲೆಂಟ್ ಮೆಂಬರ್ಸ್ ಅಫಿಡವಿಟ್ ನಲ್ಲಿ
ಎಕ್ಸಾಮಿನೇಷನ್ ಚೀಫ್
ಕ್ರಾಸ್ ನಲ್ಲಿ ಲಾಸ್ಟ್ ಪೇಜ್ ನಂಬರ್ 13. ವಾಟ್ ಈಸ್ ದ ಡಿಫರೆನ್ಸ್ ಬಿಟ್ವೀನ್ ಯು ಅಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ ಒಂದು ಕ್ವಶನ್ ಕೇಳ್ತಾರೆ. ಐ ಡು ನಾಟ್ ನೋ, ಶಿ ಶುಡ್ ಓನ್ಲಿ ಸೇ ಅಬೌಟ್ ದಿಸ್ ಅಂತ. ಏನ್ ಡಿಫರೆನ್ಸ್ ಅನ್ನೋದೇ ಆತ ಗೊತ್ತೇ ಇಲ್ಲ. ಕ್ರೂಯಲ್ಟಿ ನಾನು ಏನ್ ಮಾಡಿದೆ, ಹಿ ಹ್ಯಾಸ್ ಟು ಸೇ. ಇಲ್ಲಿ ಎಲ್ಲಿನೂ ಇಲ್ಲ. ಇವನ್ ಇನ್ ಎಂಟೈರ್ ಡಿಪೋಸಿಷನ್ ನಲ್ಲಿ ನನ್ನ ಮೇಲೆ ಯಾವುದೇ ಅಲಿಗೇಷನ್ ಇಲ್ಲ. ಡಿಸರ್ಷನ್ ಸಂಬಂಧಪಟ್ಟು ಹಿ ಹ್ಯಾಸ್ ಅಡ್ಮಿಟೆಡ್ ಎಟ್ ಪೇಜ್ ನಂಬರ್ 9 ಆಫ್ ದಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್.
ಯುವರ್ ಸಜೆಷನ್ ವಾಸ್, ವಾಟ್ ಈಸ್ ದಿ ಡಿಫರೆನ್ಸ್ ಆಫ್ ಒಪಿನಿಯನ್?
ನಥಿಂಗ್ ಇಸ್ ದೇರ್.
ಯುವರ್ ಸಜೆಷನ್, ನೀವು ಕ್ವಶನ್ ಯಾವ ತರ ಕೇಳಿದೀರಾ ಅದ್ರ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗುತ್ತೆ.
ಹೌದು, ಏನು ನಿಮ್ಮ ಅವರು ಇಬ್ಬರು ಏನು ಜಗಳ ಏನು ಅಂತ ಹೇಳಿ ನಮ್ ಕ್ವಶನ್.
ಐ ಡೋಂಟ್ ನೋ, ಶಿ ಓನ್ಲಿ ಶುಡ್ ನೋ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಯುವರ್ ಕ್ವಶನ್ ವಾಸ್ ನಾಟ್ ವೆದರ್ ಇಟ್ ಇಸ್ ಕರೆಕ್ಟ್. ನೀವೇನು ಅಲಿಗೇಷನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಅದು ಕರೆಕ್ಟಾ ಏನು ಅಂತ ಕೇಳಿದ್ರೆ ಅದ್ ಬೇರೆ ವಿಚಾರ. ಅದೆಲ್ಲ ನೀವು ಕೇಳ್ತಾ ಇರೋದು. ದಿ ಸಜೆಷನ್ ಈಸ್, ವಾಟ್ ಈಸ್ ದ ಡಿಫರೆನ್ಸ್ ಬಿಟ್ವೀನ್ ಯು ಅಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್? He says, I don't know, she only should know.
When
What is the use of pointing out to this one?
Kindly, my lords, page number 9 of the cross examination.
We'll read all the deposition. You don't have to read the entire thing. We'll read it. We will go through that.
I will.
Yes, ಯಾವ್ದು ರೆಲೆವೆಂಟ್ ಇದ್ರೆ ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿ.
Yes, ಅದೇ ಪೇಜ್ ನಂಬರ್, ಅದು ಡಿಸರ್ಷನ್ ಸಂಬಂಧಪಟ್ಟು ಪೇಜ್ ನಂಬರ್ 9 ಮಲಸ್. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ನಲ್ಲಿ ಡಿಸರ್ಷನ್ 2 years mandatory, that is whether complied or not.
9.
The respondent is cross examination. Further crossing, the respondent resided in my house till 9th July 2009. In the year 2010, once we had brackman. ನಾನು ಏನೋ ಬಂದ್ 2 ದಿವಸ ಒಂದು ಜಜ್ಮೆಂಟ್ ಕೊಟ್ಟರು ಅವರು. ಸುಮ್ಮನೆ ಒಂದ್ 2 ದಿವಸ ಬಂದು ಹೋಗೋದು, ದಟ್ ಇಸ್ ನಾಟ್ ಅಂತ ಹೇಳ್ಕಿಸಿಂದ ಅವರೇ ಕರ್ಕೊಂಡು. ಇನ್ ದ ಇಯರ್ 2010, once we had brought back respondent to my house. At that time, she stayed in the house for 1 month. Thereafter, she has left my house on her own. Since then, respondent didn't come to my house. That is there, sir. That is not find place in their legal notice nor in this. ಇದ್ರ ಬಗ್ಗೆ ಹೇಳೋದಿಲ್ಲ ಇಲ್ಲಿ. A child was born to respondent on 23/2/2010. It is true the naming ceremony of child was held in my house in the month of July 2010. Respondent was in my house for 1 month when she had come to naming ceremony. I do not know whether the respondent's father in his own house or residing in a rented house in Bangalore. I have visited Gulbarga once after the marriage and again visited Gulbarga after birth of a child. After birth of a child also he has visited. I have narrated these facts in my petition. It is true, after the marriage, I underwent some treatment, allegation treatment and surgery. Respondent was with me when I underwent a surgery. Respondent was staying in my house when I was in hospital. It is true, I underwent surgery for the purpose of facilitating the procurement of children. Witness voluntarily states that doctor had advised him to undergo surgery because respondent was not cooperative with me. It is true, I have stated about the doctor for the first time in the witness box. This goes to show that they have not complied mandatory period of 2 years before filing petition as far as the desertion point is concerned. Cruelty is also concerned in their petition also. There is no serious allegations against me. In the evidence also, they are not having any serious allegation. When they both failed,
ರೀನಂಬರ್ ಆಗತ್ತೆ ಸ್ವಾಮಿ ಅದು ಫಸ್ಟ್ ಬ್ಯಾಂಗ್ಳೂರಲ್ಲಿ ಇತ್ತು ಅಲ್ಲಿಂದ ಇಲ್ಲಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗತ್ತೆ ರೀನಂಬರ್
2011 ನಲ್ಲೇ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ 1/10/2011 itself they have filed. Later on we have moved a petition for transfer to this honorable court and the order passed with this honorable court. The case was from family court Bangalore to Gulbarga, renumbered in the 2014 number. 2011 was the earlier date they have filed. As for the desertion, they have not complied. As far as the cruelty is concerned, they have also not fulfilled the ingredients as far as the cruelty to give a divorce. Serious, that should be in the serious nature. After filing this petition, they have also not filed any restitution of conjugal rights. If I have left company, you should come and join my company.
It was for you, sir.
No, someone. They have
All the way you have been saying, I have always wanted to live with him. I wanted to live with him.
Yes.
You did not take a step by asking him to come and join you. The
That
law
was
requires you.
in between, my lords.
The law requires you to take that step.
My lords,
He is
I have
seeking-
gave a birth child.
He is seeking for divorce.
Yes.
And you are saying, no, I don't want to divorce. I want to live with him. Then who had to take the steps for seeking restitution of conjugal rights?
Before filing this petition, my lords, since I am taking a MDS course examination, pursuing my course with the permission of them only, parents' permission was taken.
Today you have not filed the petition. Till today,
I have made an effort to as per the, but my lords, as far as the after dismissal of their petition in the year 2017, they have preferred this appeal before this honorable court. They are not having right to take the benefit of after filing the petition desertion, my lords. They first fulfill their conditions as section 13(1)(a) and B2 as far as the cruelty and desertion is concerned. When they failed to comply those two conditions, they are not having any. As far as the my lords judgment is concerned, they have relied upon. In that case, my lords, even after they are separate from 10 years, but in that case, entire family members, 9 people have been implicated, their relatives, sisters, everybody in that case. They have filed a divorce case. They have filed a custody of the guardian case, DV Act case, criminal case, 488. 4 cases were pending in that case, my lords. But in this case, I have not filed any criminal case against them. I have not filed any domestic violence case against them. Recently, claiming in the year 2022 itself, I have filed a maintenance, son is concerned. I have not filed claim maintenance 125 proceedings against them, claiming maintenance for me. If I am having any ill will against them, enmity against them, I will have to definitely lodge a complete criminal case. I am having only intention to join the company of the appellant.
which is that provision that you're talking of in
Yes,
section
my lords.
13
Yes, please.
regarding desertion.
13. My lords, 13(1)(b), my lords.
Yes.
Has deserted the petitioner for a continuous period of not less than 2 years immediately preceding the presentation of the petition. They have not complied. 1 year.
My lord, it is the,
Answer?
please, my lord, the date of desertion shown in the petition cause of action is
Yes.
19/7/2009 in my petition, my lord. 19/7/2009 in my petition. Date of desertion is 19th July 2009, my lord. And the date of filing of the petition is 1/10/2011.
February 2007, they came back to India.
That is
Yes.
after the marriage.
Petitioners,
Sweden. Date of
find
filing,
out from your petition.
please. Ma'am. Eligibility. Please, madam. 11 para number 11, my lord. Para number 11 of the petition.
Yes.
The petitioner submit that though it is the duty of the respondent to live with the petitioner and lead the martial duty during his stay with the respondent, she never bothered about the petitioner's welfare and she did not discharge her duties as lawful wife. Since the respondent has deserted her matrimonial house on 19/7/2009, till date she has not returned.
So in the previous paragraphs,
Please, madam.
you point out what is the allegation? 19/7/2009.
Please, madam. In para number 6, my lord, regarding the same date, 19/7/2009.
But the respondent, instead of listening to her parents' advice, went to her
She-
parents' house on 19/7/2009 with her parents, stating that she will be back within 1 week.
With 1 week. And date of filing the petition is, my lord, it endorsed by the court authority, my lord, registration authority, filing authority, 1/10/2000.
The child was born on 23/2/2010.
Please, my lord.
Huh?
Yes, my lord, 23/2/2010.
Huh. And you admit that she came back for cradle ceremony.
Please, my lord, that we have specifically stated in my petition itself that coming back for 1 week, 10 days, 1 month, my lord, is not the where the normal life start agogatte anta. It will not come, my lord. It is only for the purpose of naming ceremony and she herself returns back. Even for the reason for that is also, my lord, it is explained in my petition. Reason is when I fix up an occasion for naming ceremony, my lord, the respondent Sushma, she comes alone. Her parents yaru baralla. ಆ ಕಾರಣಕ್ಕೋಸ್ಕರ ತಿರ್ಗಾ after 1.5 month they come to assault ಆಗುತ್ತೆ ಮನೆಯಲ್ಲಿ from once again they will go back. This is how it is pleaded in the petition. And as far as desertion, my lord, whatever the repetition, what the respondent has done, my lord, without repeating the same, my lord, in this kind of circumstances, the apex court, my lord, the judgment other day ನಾನು rely ಮಾಡಿದೆ judgments ಅಲ್ಲಿ page 67 ಅಲ್ಲಿ the apex court, if I file a petition, after filing the undertaking, my lord, in the circumstances if the respondent wife or the husband reunion ಆಗ್ತಿಲ್ಲ ಅನ್ನಂಗೆ ಅದು, the court after in the mediation failed agide, conciliation ಆಗ್ತಿಲ್ಲ ಅಂದಾಗ, after taking the undertaking, my lord, it will have, this honorable court will have discretion. I say it is 20 lakh rupees because the reason, how the respondent says that he offered 50 lakh ಆ ಕಾಲದಲ್ಲಿ ಹಿಡಿದು 2014, he has so many properties. All this, my lord, it was cross-examined in other maintenance case. None of the property details ಏನು ಬಂದಿಲ್ಲ. Only simply saying he is a rich person, he is a royal person. All these are all only the allegations. None of the proceeding, none of the papers is before the dishonorable court or in any other case. ಅದರಲ್ಲೂ ಕೂಡ ಸ್ವಾಮಿ page 67 ಅಲ್ಲಿ the list of authorities ಅಲ್ಲಿ ಇದೇ ರೀತಿ ಇರ್ತದೆ. Respondent wife will never agree Because in the similar circle, ಅದ್ರಲ್ಲೂ 10 ವರ್ಷದಿಂದ ಹಿಂಗೆ ನಡೀತಿರ್ತದೆ. Then the courts in the page number 67, my lord, 2022 5 SEC 459. Para number 13, my lord. In page 71, no, 67 in the judgment start ಆಗತ್ತೆ. Relevant page is 71, para number 13. Page 71, relevant para 13, my lord. Earlier, when this court made an effort from bringing about an amicable settlement, the appellant had offered to pay a lump sum of amount rupees 10 lakh rupees to the respondent. In facts of the case, we propose to direct the appellant to pay a sum of rupees 15 lakhs to the respondent. Hence, the impugned judgments are set aside, so and so, my lord. Marriage was declared null and void. Then, my lord, coming forward, the next para, my lord, para 15. We direct the appellant husband to deposit 15 lakh rupees in the court within period of 8 weeks. Then, my lord, in the in the relevant para is, it will be open for the respondent to withdraw the said amount so and so. It is also open for her to withdraw a sum of rupees also deposited. And so further, my lord, in the event amount deposited by the appellant in this court are not withdrawn by the respondent within the so and so period 2 months, that which some rupees is deposited, registry shall place before the court for issuing necessary directions. From 2000, now none of the replies were given by the other side for why not filing restitution, suppression, my lord. Once again, repeating the same thing, what is not there on the record, my lord. Hence, in this background, my lord, the appeal may be allowed.
What is that? You please clarify about that 5 addresses you said.
Please, my lord.
She kept on changing.
Please, my lord.
What that?
In the petition, my lord,
Yes.
exhibits are produced. In the judgment, my lord, I have marked the legal notice which were unserved. Para number 8 ಇದೆ ಸ್ವಾಮಿ. Para number 8, last 4 lines, my lord. Last 4th line, my lord. It is further submitted that after 6 months, the respondent changed her residence and petition ali para number 8, my lord. Para number 8 of my divorce petition.
Yes.
Last 4 lines, my lord. It is further submitted that after the 6 months, the respondent changed her residence and did not give information regarding her new residence when the petitioner tried to contact her through the phone. Respondent did not respond. The petitioner, even to this day, the respondent did not disclose her new residential address. This is how it was, my lord. After walking out, they changed. Before this honorable court, we stated the Gulbarga's parents' house address and their college address, my lord, in my petition.
At that point of time, she was still studying.
Yes. At the time of marriage itself, after the marriage, my lord.
When you filed the petition and you gave the address, she was still studying. Then why did you give this address then?
Please, my lord. ಓದ್ತಿದ್ರು ಅವರು, because I was only taking her to the college also, my lord.
ಅದ ಅವಾಗ ಆಯ್ತ್ರಿ, ನೀವು ಪೆಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದಾಗ you have given 2 addresses.
Please, my lord.
You have also given the address of her college institution.
MD ಮಾಡ್ತಿದ್ರು ಸ್ವಾಮಿ. MD ಮಾಡ್ತಿದ್ರು.
She was doing
please,
MD.
please. Yes, ma'am.
When the petition was filed.
Yes.
Finally, BDS. Final year BDS.
BDS ಮಾಡ್ತಿದ್ರು. BDS ಮಾಡ್ತಿದ್ರು. 5 years BDS ಮಾಡ್ತಿದ್ರು.
ಮತ್ತೆ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ.
Please, my lord.
5 address.
ಅಲ್ಲ.
BDS.
At the time of issuing
BDS
legal address.
Correct.
Please.
Please. ಆಯ್ತು. ಆಮೇಲೆ before this court, what address have you given?
Before this address, before this honorable court.
Bangalore.
Gulbarga address and
sorry.
also college address.
Same. Petition ಅದೇ address.
ಈ court ಅಲ್ಲಿ, please, ma'am.
Same address.
Same. Here ಇದರಲ್ಲಿ ಬಂದು ಕಾಲೇಜ್ ಅಡ್ರೆಸ್ ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ at the time of ಗುಲ್ಬರ್ಗ ಅಡ್ರೆಸ್ ಹಾಕಿದ್ದಾರೆ.
Tadkal village.
This is their native place wherein they are not residing. but they are having landed property there.
Ah.
Only to make humiliation,
Ah.
ಎಲ್ಲಾ ಕಡೆ 5 ಅಡ್ರೆಸ್ ಎಟ್ ಎ ಟೈಮ್ ಕಳಿಸ್ತಾರೆ ಅವ್ರಿಗೆ. 2 ಕಡೆ ಸರ್ ಅವತ್ತು 3 ಕಡೆ ರಿಟರ್ನ್ ಎಲ್ಲಿ ಇರ್ಲಿಲ್ಲ. ಬಾಡಿಗೆ ಮನೆಯೊಳಗೆ ಇದ್ದಾಗ ಒಂದೇ ಇನ್ನು ರೆಂಟೆಡ್ ಹೌಸ್ ಮನಿ ಚೇಂಜ್ ಮಾಡಿದಾಗ ಮೊದಲಿನ ಮನೆಗೂ ಅಡ್ರೆಸ್ ಕಳಿಸ್ತಾರೆ. ಓಲ್ಡ್ ಹೌಸ್ ನಲ್ಲಿ ರೆಂಟೆಡ್ ಹೌಸ್ when they have changed their rented house ಮತ್ತೊಂದು ನ್ಯೂ ಹೌಸಿಗೆ ಹೋದಾಗ
ಎಲ್ಲಿ
ಬೆಂಗಳೂರಿನಲ್ಲಿ ಇದ್ದು ಒಂದು ಅಡ್ರೆಸ್ ನಲ್ಲಿ ಅದರಲ್ಲಿ ಅವ್ರು ಇರ್ತಿರ್ಲಿಲ್ಲ ಮೊದಲು ಚೇಂಜ್ ಮಾಡಿದ್ದಾರೆ.
ಲೆಟರ್ಸ್ ಗಳು ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿದಾಗ
ಎಲ್ಲ ವಾಪಸ್ ಬಂತು ಒಂದೇ ಸರ್ವ್ ಆಗಿದೆ.
ಯಾವ ಅಡ್ರೆಸ್ ಕಳಿಸಿದ್ರಿ?
To all these 5 addresses.
All that happened when you were still studying MD.
BDS art.
Letters correspondence. Letter correspondence happened when you were studying BDS. ಆದ್ಮೇಲೆ ಯಾವ ಅಡ್ರೆಸ್ ಯಾವ ಚೇಂಜ್ ಮಾಡಿದ್ರು? when they change the address?
This is they after going from 2009, after going from 2009, they changed all the communication contact addresses.
Your parents were also staying in Bangalore?
We stayed in rented house.
Rented house.
Convenience, we used to change the houses, that's all.
Why, how is it that he was your parents were staying in Bangalore?
Sir, ಮತ್ತೆ ಬ್ಯಾಂಗ್ಳೂರ್ಗೆ ಮಾಡ್ಬೇಕು ಅಂತ ಪಾಪ ಅವ್ರು ಅಲ್ಲೇ ನಮ್ಮ ಎಜುಕೇಶನ್ ಅದು ಇದು ಲೈಫ್ ಬ್ಯಾಂಗ್ಳೂರ್ಗೆ ಇದಾಗುತ್ತೆ ಅಂತ ಎಜುಕೇಶನ್ ಮುಂಚೆನೆ ರೆಂಟ್ ತಗೊಂಡು ಇದ್ದೀವಿ ಸರ್. ಸೊ ಅಲ್ಲೇ ನೋಡಿ ಅಲ್ಲೇ ಮದ್ವೆ ಮಾಡಿದ್ವಿ.
Marriage was also performed with them only. Entire expenses was borne by them only.
ಅಲ್ಲ, we are talking of the addresses.
Yes,
Please, regarding this in the statement of objections.
ವಿಲೇಜ್ ಕಳಿಸ್ತಾರೆ.
In the
ಇಲ್ಲಿ
statement of
ಗುಲ್ಬರ್ಗದಲ್ಲಿ ಬೇರೆ ಬೇರೆ ಅಡ್ರೆಸ್ ಕಳಿಸ್ತಾರೆ.
ಇದನ್ನ ಸಂಬಂಧಪಟ್ಟಂಗೆ in the statement of objections, Your Honor, they filed the statement of objections regarding the para what I stated in my petition. Kindly peruse to the statement of objections. Para number 7 of the statement of objections. They simply evasively deny as false. Para number 7 of the statement of objections regarding this addresses. For that, what they say is, after the 6 months, the respondent changed her residence and did not give the information regarding her new residence, and that when the petitioner tried to contact her through phone, her residence did not respond the petitioner, that even to this day, respondent did not disclose her new address is all denied as false. If that was the case, they could have specifically stated in the pleadings, my lord, governments. Simply an evasive denial, my lord, not specifically denied, my lord.
ರಿಜಿಸ್ಟರ್ಡ್ ಅಡ್ರೆಸ್ ಬಗ್ಗೆ ನೀವು ಡಿಕ್ಲರೇಷನ್ ಹಾಕ್ಬೇಕು ಆಕ್ಚುಲಿ.
Please, my lord, exhibits mark ಮಾಡ್ಬಿಡಿ.
ಅದನ್ನ ಯಾರು ಫಾಲೋ ಮಾಡ್ತಾ ಇಲ್ಲ ಬಿಡಿ.
ನೀವು ಡಿಕ್ಲರೇಷನ್ ಹಾಕಿ.
Please, my lord, I heard the other matter when it was running, my lord. So we have to keep that in the practice. We have to keep in mind and we have to give a declaration all the parties.
ಚೇಂಜ್ ಆದಂಗೆಲ್ಲ ನೀವು ಡಿಕ್ಲರೇಷನ್
ಹೌದು ಸರ್. 614 ಪ್ರಕಾರ that is what is the CPC.
All right. As far as the Mallards, their contention 2009 is concerned, they have suppressed in their petition as well as what I have earlier submitted. 2009 ಬಿಟ್ಟು ಹೋದ್ರು ಅಂತ 1907 ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ petition ಅಲ್ಲಿ. As per the cradle ceremony, ನಾನು ಅಲ್ಲಿ 1 ತಿಂಗಳು ಬಂದು ಅದ್ರ ಬಗ್ಗೆ ಹೇಳೇ ಇಲ್ಲ. In their petition itself, in their effort, class ನಲ್ಲಿ admit ಮಾಡ್ತಾರೆ. To show only 2 year ತೋರ್ಸೋ ಸಂಬಂಧಪಟ್ಟು 1 ತಿಂಗಳು ನಾನು ಅಲ್ಲಿ ಹೋಗಿದ್ದು.
Even now they are contending in terms of the judgment of the Supreme Court, that would not amount to you are coming and staying with him. The word desertion, as explained by the Supreme Court, they say merely coming back and staying for a few days would not amount to
Yes,
restitution of
I do agree. As far as this case is concerned,
prakara, that cannot be considered as a fact that you have already come and you are staying with him, and you cannot consider that is the contention.
Yes, their contention is that. One minute. Mallards, as far as my contention is concerned, ನಾನು ಪ್ರೆಗ್ನೆಂಟ್ ಇದ್ದೆ, ಡೆಲಿವರಿ ಸಲುವಾಗಿ ನಾನು ತವ್ರ ಮನೆಗೆ ಹೋಗಿದ್ದೆ. ಆಫ್ಟರ್ 5 months ಆದ ನಂತರ ಅವ್ರು ಕರ್ಕೊಂಡು ಬಂದು ಕ್ರೆಡಲ್ ಸೆರೆಮನಿ ಮಾಡಿದ್ರು. 1 ತಿಂಗಳು ನಾನು ಅಲ್ಲಿ ಇದ್ದೆ. As per their admission, these are the facts. That doesn't mean that delivery ತವ್ರ ಮನೆಗೆ ಹೋದಾಗ that doesn't mean come under the purview of the desertion, Mallards. ಹೆಣ್ಣು ಮಗಳು ತವ್ರ ಮನೆಗೆ ಡೆಲಿವರಿ ಹೋಗೋದು, BDS ಪರ್ಸ್ಯೂ ಮಾಡೋ ಸಂಬಂಧಪಟ್ಟು ಹೋಗೋದು with their permission only. Before marriage was, that was agreed by them. Prior to marriage itself, ಪರ್ಸ್ಯೂ ಮಾಡೋ ಸಂಬಂಧಪಟ್ಟು ನನಗೆ ಪರ್ಮಿಷನ್ ಕೊಡಬೇಕು ಅಂತ ಕೇಳಿದಾಗ, even after pendency of divorce petition before the family court also, they have 2-3 times made effort ಮನಿಗೆ ಹೋಗಿದ್ದಾರೆ. ಮನಿಗೆ ಹೋದಾಗ ಒಂದು ಸಲ ಪೊಲೀಸರು ಕರೆಸಿ ಮೊದಲು 2 ಸಲ ಬರಬೇಡ ನಮ್ಮ ಮನಿಗೆ ಅಂತೇಳಿ ಪೇರೆಂಟ್ಸ್ ಹೊರಗಡೆನೆ ಹಾಕಿದಾರೆ. ದಟ್ ದಿ ಹರ್ ಸೆಲ್ಫ್ ಹ್ಯಾಡ್ ಬೀನ್ ಟು ದೇರ್ ಹೌಸ್. ನಾನು ನನ್ನ ಸೊಸೆ ಇದ್ದೀನಿ, ನಾನು ಬರ್ತೀನಿ ಮನೆಯಲ್ಲಿ ಅಂತ
Overall
ಹೋದಾಗ
out of
ಇವನ್
effort.
ಪೆಂಡಿಂಗ್ ಇದ್ದಾಗೂ ಸಹಿತ
Everything
ವಾಟ್ ಮೈ
out
ಲಾರ್ಡ್
of
ಹ್ಯಾಸ್
effort.
ವಾಟ್ ಎಫರ್ಟ್ ಯು ಹ್ಯಾವ್ ಮೇಡ್ ಅಂತ ಕೇಳಿದಾಗ ನಾನು ಅದೇ ಕೇಳಿದೆ ಯಾಕಿದ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂತಂದಾಗ 2 ಸಲ ಹೋಗಿದ್ದು, 3ನೇ ಸಲಕ್ಕೂ ಸಹಿತ ಇಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದ್ದಾಗೂ ಸಹಿತ ಹೈಕೋರ್ಟ್ ನಲ್ಲಿ ಮ್ಯಾಟರ್ ಪೆಂಡಿಂಗ್ ಇದ್ದಾಗೂ ಸಹಿತ ಪೊಲೀಸರಿಗೆ ಫೋನ್ ಮಾಡಿ ಪೊಲೀಸರು ಬಂದು ಕರ್ಕೊಂಡು ಹೋಗಿ ಬಾಂಡ್ ತಗೊಂಡು ಹೈಕೋರ್ಟ್ ನಲ್ಲಿ ಕಂಪ್ಲೀಟ್ ಆಗುವವರೆಗೂ ನೀವು ಅವ್ರ ಮನೆಗೆ
Mere
ಹೋಗಬೇಡ
words ಅನ್ನೋದು.
ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ರೆ ಅವ್ರ ರೆಕಾರ್ಡಿಂಗ್ ಅಲ್ಲೇ ಇದೆ ಸರ್ ಅದು ಸೆಂಟೆನ್ಸ್. ಕೇಳಿದ್ರೆ ಇಲ್ಲ ನಿಮ್ಮ ನೇಬರ್ಸ್ ಬಂದ್ ನನಗೆ ಮುಖದ ಮೇಲೆ ಅಂತಾರೆ, ನಿಮ್ ಗಂಡ ಇಲ್ಲಿ ಇರೋದೇ ಇಲ್ಲ, 15 ವರ್ಷದಿಂದ ಎಲ್ಲಿ ಹೋಗಿದ್ದಾನೋ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸರ್. ಅದಕ್ಕೆ ನಾನು ಅಂದೆ ಇಲ್ಲ ಅವ್ರಿಲ್ಲ ಅಂದ್ರೆ ನಾನ್ ಇರ್ತೀನಿ ಬಿಡಿ ಅಂದ್ರೆ ಪೊಲೀಸಿಗೆ ಕರ್ಸಿ ಹೊರಗೆ ಹಾಕಿದ್ದಾರೆ ಸರ್.
All these mere statements, my lord, not nothing in actual reality.
All right, we'll consider.
I have filed the affidavit, my lord, in this.
Heard, reserved.
Please.
Counseling. Then subsequently, my lord, another special spray round was conducted. And my lord, 2 vacancies were filled. Now, my lord, there is finally 1 vacancy. Today is the last date, my lord, of the apprehension of the college is not only, my lord, a student will be deprived of a seat, but also, my lord, the college will be deprived of the revenues. Now, the seat being vacant, my lord, my lord, representation was immediately given, my lord, to the respondent number 2 and 3, not to make arrangement, my lord, to fill
Mr.
up the
Senior
vacancies. The
ಹೇಳಿ.
Please, Manoj, we are, one NRI seat is remained vacant, Manoj. What we have requested them to is convert the NRI seat into management seat, Manoj. In fact, Manoj, usually the seats has to go, cannot go unfilled, Manoj. The Supreme Court in 2010 SEC 225, the judgment copy is given to my learned friend, para 10, as permit, para 28, as permitted NRI seats to be converted to.
2010.
Please.
ತಂದಿಲ್ವಾ?
There was some communication gap, my lord.
ಅವ್ರ ಹತ್ರ ಇಲ್ಲ ಅಂತೆ 2010 judgment.
ನಾನು ಓದ್ಲಾ Manoj? I'm sorry.
ಹಾ.
A plain reading of the above leaves no manner of doubt that unfilled NRI seats has to be transferred to general pool to filled up on the basis of merit of the candidate in the state level common entrance test conducted by Madhya Pradesh by any other agency authorized by the state for the said purpose. Unfilled seats in NRI quota were therefore to be treated as part of the general pool. Once they are done, the share of the college in terms of the order that this court would 50% of the set seats. The High Court has in the view rightly held, and while the management seat was justified in filling up 5 unfilled NRI quota and the remaining could not have been filled otherwise than on the basis of entrance test referred to in Rule 8. So therefore, my lord, this NRI seat having fallen vacant, it can be converted to management seat, which is a lesser fee, my lord, and to be filled up by the central government. We are not saying that we have to fill up, my lord. Let them fill up this NRI seat
But,
under management
it,
quota by the central government itself and send a
But
seat to us.
it is a fact that two more round of counseling were held
Correct, my lord.
at your request to fill up
Not
those.
for all India, my lord, not only for our institution, throughout India. Not for not only individual, my lord. These are first round is conducted, second round is conducted, third round is conducted, stray rounds are conducted because seats kept falling vacant, my lord. It's not only for our institution.
Yes.
For
Any instructions?
No, ma'am. At present, I had no instructions.
Today is the last day. Na?
please, your lordship may only direct the central government to fill up the seats, unfilled seat under management quota. That's all, my lord. Because today is the last day.
Judgment. Please give that citation again.
2010 10 SEC 225.
Name of the parties?
Name of the Monica Ranka, sorry, RD Gardi Medical College, RD Gardi, GARDI Medical College versus State of Madhya Pradesh, para 28. And there's one. Requesting is, my lords, let the central government fill up the, because, my lords, there will be hundreds of students waiting for a medical seat, my lords. It's not that there's throughout India. Let them only fill up at the management, which is a lesser fee rate, and send them to our institutions, my lords. Can your lordship kindly turn to page 28 for a moment, my lord? Page 28 for a moment, my lord.
28 of?
The writ petition for a moment, my lord.
Annexure A.
Annexure A. Second, last paragraph. In view of this, colleges are requested to intimate if they intend to convert their unfilled or unallotted NRI seat to management quota, so the same can be considered for the mop-up round. So we have given a representation, Malos, to convert. This is the regulations of the MCI, Director General of Health Sciences. So in terms of this, as well as para 28 of the Supreme Court judgment, Malos, let them.
Why is the apprehension there with you? We can't understand. After
Because
you have
today
said 6 seats in your institution have remained unfilled, and thereafter they conducted mop-up round and again a special round.
Please, my lord.
Out of 6, 5 are filled up. 1 is remaining vacant.
Under NRI quota, they are filled up 5.
NRI then. We are talking of NRI only.
Correct, Murad. Now today the NRI students are not available, but there are other general candidates, Indian students who are available. Let them be filled up by Indian students under them by the Director General of Health Sciences, Murad.
That is not the tenor of this judgment that you are citing now.
Tenor of the judgment is NRI seats can be converted to general seats. Tenor of the judgment is NRI seats can be converted to general seats, Malad.
Yes.
I'll just read it, Malad. Tenor of the judgment at para 28 at page 233 is the plain reading of the above leaves no manner of doubt that
paragraph?
Para 28, page 233. A plain reading of the above leaves no manner of doubt that unfilled NRI seats has to be transferred to the general pool to be filled up on the basis of merit of the candidates in the state level common entrance test conducted by Madhya Pradesh so by any other agency authorized by the state government for the said purpose. Unfilled seats in NRI quota therefore to be treated as part of the general pool once they are done the share of the college in terms of the order passed so and so. High Court has in that view rightly held that the management was justified in filling up unfilled NRI seats. The remaining 5 seats could not have been filled up otherwise on the basis of entrance test. So therefore, my lord, if the court upheld the judgment of the High Court where the management has filled up the NRI quota under the NRI seats under the management quota. My last sentence. The High Court has in that view rightly held that while the management was justified in filling up 5 unfilled seats in NRI quota of remaining 5 seats could not have been filled up otherwise other than the entrance test referred to. Maloj, here Maloj, we are not saying that we'll admit the students, Maloj. We are saying that let the central government agency fill up the seats under the management quota. If I go for NRI seats, I may not get NRI seats today, Maloj. I want any other Indian student to get the seat.
It's not out of.
Barkul. Learned Deputy Solicitor General of India, who is present in the court, takes notice for
1 and 2.
response number 1 and 2. This National Medical Commission ಯಾರ ಪೇರ್ ಆಗ್ತಾರೆ ಇಲ್ಲಿ?
I have made inquiries, my lord. There is nobody here.
ಬೆಂಗಳೂರೇ.
Kheti, my lord. Nuruddin Kheti.
Learned Counsel Shri
Nuruddin
NR
Kheti.
Kheti.
Please.
He is requested to take notice for respond number 3. Issue notice to respond number 3. Issue emergent notice to respond number 3. Full stop. The petitioner is also permitted to serve a copy of the petition on Learned Counsel Shri NR Kheti, who normally appears for respond number 3.
Soft copy is served, my lord.
Madidira?
Madidi.
Full stop. Office is directed to show the name of Learned Counsel Shri NR Kheti for respond number 3. Full stop. Learned Counsel for the petitioner is also directed to serve copies of the petition along with annexures on Learned DSG. Full stop. Next para. Learned Senior Counsel Shri Shashikiran Shetty, appearing for the petitioner institutions, has drawn the attention of this court to Annexure A, which is a notice issued by
MCC.
Illa Government of India,
Directorate of
ADG. Under respond number 2, issued by notice dated 9/12/2020. 2020 na?
2020.
2020, Maloj. Maloj, this is the.
ಅವಾಗ ಮಾಡಿದಾಗ ಈ ತರ ಪ್ರೊಸೀಜರ್ ಫಾಲೋ ಮಾಡಿದ್ರು ಅಂತ ತೋರ್ಸಕ್ಕ?
No, even the procedure is as per now also that's the same procedure.
Correct. So the same procedure has to be followed now also anta. That is
please, correct. I bow down to your lordship.
Issued by the second respondent. Full stop. It is pointed out that earlier too, the second respondent has followed this procedure where the colleges were requested to intimate the authority if they intended to convert their unfilled or unallotted NRI seats to management quota so that same may be considered for mop-up round. Full stop. Learned Senior Counsel submits that it is true that after the initial rounds of counseling, 6 seats in NRI category of MBBS remained unfilled in the petitioner institution. Full stop. Thereafter, mop-up round was conducted and special round was also conducted wherein 5 seats out of 6 have been filled up. Full stop. However, there is 1 seat that is remaining vacant and therefore appropriate directions are being sought in this writ petition. To respond number 2, and 3, to convert the vacant bar unfilled bar unallotted 1 NRI MBBS seat to general seat bar unreserved bar management seat and transfer the said 1 seat to the petitioner university as per the MCC notice dated 9/12/2020 at Annexure A. Next para. Attention of this court is also drawn to a judgment of the Honorable Supreme Court in the case of R.D. Gardi Medical College and another versus State of Madhya Pradesh and others, bracketed 2010, close 10 SCC 225. Where Rule 8 of the Admission Rules, 2008 were considered. And it was held that a plain reading of the rules leaves no manner of doubt that unfilled NRI seats had to be transferred to the general pool to be filled up on the basis of the merit of the candidates in the state level common entrance test conducted by the Madhya Pradesh Vyavasayik Pariksha Mandal or by any other agency authorized by the state government for that purpose. Full stop. Learned Senior Counsel submits that the position remains same even in the NEET regime. And therefore, such directions are sought at the ends of this court. Full stop.
2020 was also NEET regime itself, my lords.
Huh?
2020 also was NEET regime itself, my
It
lords.
is further submitted that Annexure A is a notice issued in the year 2020 during the NEET regime, and therefore the position remains same. Full stop. Next para. Consequently, we direct respondents number 2 and 3 to consider the request made by the petitioner institution to convert same other words ಹಾಕ್ಬೇಕು ಹೇಳಿದ್ನಲ್ಲ ಅವಾಗಲೇ full stop. As requested by the Learned Senior Counsel, respondents number 2 and 3 may take a decision to fill up the seats through the counseling held by respondent number 2. comma, as to, today is the last date of counseling,
Yes, my lords. Today is the no council, they'll have to admit one student, they have to send one student to our institution, my lord, under the management quota, my lord.
The last, last sentence. And not necessarily that the petitioner institution should be permitted to fill up the seat. You can also do it.
Please, my lord.
We are not directing you to permit them to fill up the seat. That is different. Counseling ಅಲ್ಲಿ ನೀವೇ fill up ಮಾಡಿ ಅದನ್ನ ಅಂತ ಹೇಳ್ತಾ ಇರೋದು ನಾವು. And you understood?
Because tomorrow if we fill up, they may say that it is not correct, they should have
So
given it to
that,
somebody else.
We are not giving that direction, that they may fill up ಅಂತ ನಾವು ಕೊಡ್ತಾ ಇಲ್ಲ. We are saying, if it is permissible to conduct one more counseling, you please do it, because seat should not go unfilled.
Please.
So you yourself can fill it by a deserving candidate, but don't leave it vacant. The entire wisdom behind the directions issued by the Supreme Court, Honorable Supreme Court, is that no seat should go unfilled. Full stop. Next para. Release this matter on 9th of December, Monday. Yes.
Grateful to my lord.
A copy of this order shall be served on the learned DSG. Please collect it.
Please.
Yes. All other matters will not be heard today.